Good. Good afternoon and welcome to the Judiciary Committee. My name is Patty Pansing Brooks and I'm from Lincoln, representing District 28 right here in the heart of Lincoln. I'm the Vice Chair of the Judiciary Committee, and I'd like to start off by introducing members of the committee who are here, starting on my right.
Yes. Julie Slama, District 1, covering Otoe, Pawnee, Richardson, Johnson, and Nemaha counties.
Tom Brandt, District 32, Fillmore Thayer, Jefferson, Saline, and southwestern Lancaster counties.
And assisting the committee today are Lori Volertson, our committee clerk, Neil Erickson and Josh Henningsen, our two legal counsels. The committee pages are Alyssa Lund and Dana Mallett, both students at UNL. On the table inside the doors, you will find the yellow testifier sheets. If you're planning on testifying today, please fill out one and hand it to the page when you come up to testify. This helps us keep an accurate record of the hearing. There is also a white sheet on the table if you do not wish to testify, but would like to record your position on a bill. Also, for future reference, if you are not testifying in person on a bill and would like to submit a letter of support for the official record, all committees have a deadline of 5 p.m. the day before the hearing. We will begin bill testimony with the introducer's statement, followed by the opening. We will hear from proponents of the bill, then opponents, and finally by anyone speaking in the neutral capacity. We will finish with a closing statement by the introducer if they wish to give one. We also ask that you begin your testimony by giving us your first and last name, and please spell them for the record. We utilize an on-deck chair right up here next to the left, to your left of the testifier's table. Please keep the on-deck chair filled with the next person to testify in order to keep the hearing moving. If you have any handouts, you're welcome to bring up at least 12 copies and give them to the page. And if you do not have enough copies, the page could help you make some more. We will begin using, we will be using the light system. It's this box up here with the colored lights. When you begin the testimony, the light on the table will turn green. The yellow light will come on when, as your 1 minute warning, 1 minute left. And when the red light comes on, we ask you to wrap up your final thought and stop your testimony. As a matter of committee policy, I'd like to remind everyone that the use of cell phones and other electronic devices is not allowed during the public hearings. Those senators may use them to take notes or stay in contact with staff. At this time, I'd ask for everyone to look at his or her cell phone and make sure that they are on silent mode. Also, verbal outbursts or any applause is not permitted in the hearing room, and such behavior may be cause to be asked to leave if leave this hearing room. And one more thing, you will notice committee members coming and going. That has nothing to do with the importance of the bill or a specific senator's position on a bill, but the senators have bills to introduce in other committees or other committee meetings to attend. So with that, we will begin today's hearings, and first we have the gubernatorial appointments. We have 3 of them to the Crime Victims Reparation Committee, and first we will have Michelle Schindler. Welcome.
Hi, good morning.
Please begin.
Okay, I'm Michelle Schindler. I hail from Lincoln, Nebraska. Went to Northeast High School and then attended the university and studied criminal justice and then got my master's in family sciences. I began working with the Crime Commission back in the 80s for an undergrad intern with their computer and CGIS program, and then began working and running the youth center in Lancaster County. I don't know what else you want to know about me. I have a 19-year-old son who lives in Colorado Springs. I come from a small business family, agriculture, and from Hardington, Nebraska. And I'm on the Crime Commission, and I was asked to be on the CVR committee. I do appreciate your support for the victims of crime. I think restorative justice is very powerful. It's very powerful. And I think that the way in which you obtain funds to help restore the victims of crime means a lot. We've seen requests for funeral services, for education, for therapy, and I think recovering from being a crime victim is a lifelong journey. But this committee and this state's response to those who are in need says a lot about all of you and all of us as a community and state.
Thank you, Ms. Schindler. Are there any questions? Yes, Senator Brandt.
Thank you for appearing today. How many years have you served on this commission?
This would be my circuit on the Crime Commission or specifically on the CVR, or both?
Both.
Okay, I've been on the Crime Commission approximately 6 years, and this would be my second term on the CVR committee.
If you had the opportunity to change anything, would you change anything?
Well, personally, I do think that the requests exceed the revenue that we have to provide. So looking at alternative funding sources, I don't know necessarily if it would be taxes, or general funds. But I do like that a portion of what the inmate goes to supports this program. And I think that could be evaluated. I think that for recovery and for those who have committed harm, I think it's important for them to understand their responsibility to help make people whole. And I think it's all about restorative justice.
Okay, thank you.
Thank you, Senator Brandt. Any other questions? I just want to add that I have had the good fortune of working with you in a number of areas, and I really appreciate your effort and your advocacy. And I see that you won the Excellence in Detention Facility Administration 2008 award, and so I appreciate all your work.
Thank you.
Thank you. Any other questions? No. See none. I don't know if people are here, or if you have any proponents that would like to speak, or opponents. Anybody in the neutral? Okay, thank you, Ms. Schindler.
Thank you.
This closes the hearing on the gubernatorial appointment of Michelle Schindler. And we do have a letter of support from Larry Dix from the Nebraska Association of County Officials. Next, I'd like to open the gubernatorial appointment for Sean Etherton to the Crime Victims Reparations Committee. Welcome, Mr. Etherton.
Thank you. I'm Sean Etherton, S-H-A-W-N, Etherton, E-A-T-H-E-R-T-O-N. And I appreciate the opportunity to be in front of you here today. I'm the Buffalo County Attorney by trade and have been so. This just started my 5th term out in Kearney. I also serve as an adjunct professor at the University of Nebraska at Kearney. I'm the past president of the County Attorneys Association, and I serve on the NACO board as the attorney's representative right now. I certainly believe very much in restorative justice. I believe that the CVR is, unfortunately, it's kind of the port of last harbor for many people. And
Could you pull that just a little closer? I'm sorry.
Certainly.
Yeah, thank you.
Is that better? I do believe in the CVR. I believe it is the port of last harbor for many people. It's their last opportunity, and it is unfortunate the limitations that we have, but they are there, and the CVR, I think, does the best it can to put people in the position that they can to make ends meet in the end of the day. And they are sad situations, but they are caused by other people, and the best we can do for the victim at times is give them some financial assistance.
Thank you, Mr. Etherton. Any questions for Mr. Etherton? Okay, thank you for coming today. Any proponents in support of Mr. Etherton's appointment? Any opponents? Anybody in the neutral? So we do have I think we have a letter of support, yes, from Larry Dix from the Nebraska Association of County Officials, and that will close today's appointment on Crime Victims Reparation Committee for Mr. Sean Etherton.
Thank you, Senator.
Thank you for coming today.
Thank you.
Okay, and finally, we are going to be having the gubernatorial appointment to Crime Victims Reparation Committee with Mr. Thomas Parker. I understand is he calling in? Oh, okay. Excuse me. So he did submit a letter for the record, and we do have that letter. We will recognize the fact that his background includes 37 years as a sworn law enforcement officer with the Nebraska State Patrol, and he retired in 2009 as captain and troop commander of the 11 Panhandle counties. So he was appointed originally for the Crime Commission in 2017, and so we will recognize that letter. And are there any proponents in support of Mr. Parker, or opponents, people in the neutral? Seeing none, there are no additional letters, and that closes the 3 gubernatorial appointments that we had to the Crime Victims Reparation Committee. Thank you. Now, we're going to open the hearing on LB 689, and if those who are prepared to testify would come forward, and we have Senator Kavanaugh. Yeah, I will. Yeah, that's okay. Welcome, Senator Kavanaugh.
Thank you, Vice Chairwoman Pansing Brooks, and to the committee. I am Michaela Kavanaugh, M-A-C-H-A-E-L-A-C-A-V-A-N-A-U-G-H, Senator for District 6 in West Central Omaha. LB 689 was introduced, prohibits housing discrimination on the basis of sexual orientation, gender identity, or citizenship status. And I do have an amendment, which I have copies of. Current law forbids discrimination on the basis of race, creed, religion, color, national origin, sex, handicap, and familial status. This bill would extend the same protection to members of the LGBT community and to those who are non-citizens. Specifically, under LB 689, it would be unlawful to refuse to rent or sell to tenant or buyer on the basis of their sexual orientation, gender identity, or citizenship status. This law amends the Nebraska Fair Housing Act. This is a comprehensive act that, according to the stated legislative intent, prohibits discrimination in the acquisition, ownership, possession, or enjoyment of housing throughout the state of Nebraska. Current law prohibits restrictive covenants, a limitation on the transfer of housing, from being based on race, religion, or any other prohibited factor. Section 1 of the bill, and my amendment to 95, would extend this prohibition to LGBT and citizenship status. Current law also prohibits sellers or landlords from refusing to sell or lease property or to discriminate in terms of a lease or sales contract to any person because of their race, color, or other prohibited factor. Section 2 of the bill would extend these prohibitions to LGBT and citizenship status. Section 5 of the bill would bar landlords from denying rental on the basis of sexual orientation, gender identity, or citizenship status. The bill furthers our state's commitment to equality before the law. It is a broadening of the prohibition against arbitrary discrimination. The bill still allows for exemptions for religious organizations and for private homes. Section 28-322 of the Fair Housing Act exempts religious organizations, people who rent rooms or a portion of their private homes to others, private clubs, and housing for older people. These exemptions remain the same with this bill. In other words, people will still have the ability to determine, for any reason, who may live in their homes. Only those landlords or real estate transactions that are subject to the existing Fair Housing Act are affected by this bill. Current law prohibits discrimination based on national origin or race. To ensure that all are protected, this bill would include citizenship status as a factor that a landlord or seller may not consider. I appreciate that landlords or sellers may request documentation or conduct inquiries to determine whether a potential renter meets the criteria for rental, so as long as the same procedure is applied to all potential renters. Landlords can ask for identification documents or identifying information, or can institute credit checks to ensure ability to pay rent. Under LB 689, landlords may not refuse to rent or sell to persons solely because they are not a U.S. citizen. This is because a person's ability to pay rent or their fitness as a tenant is not necessarily connected to their citizenship status. With respect to extending LGBT protection, by enacting this bill, we will join an ever-growing list of states that have extended housing protections to LGBT people. 22 states and the District of Columbia protect against housing discrimination on the basis of sexual orientation. 20 states in the District of Columbia protect against housing discrimination on the basis of gender identity. I've brought an amendment today to do two things. First, it ensures that a landlord or seller may conduct eligibility checks that are required under any state or federal law. Some housing programs require that a tenant be a U.S. citizen or eligible resident. So this amendment allows for a landlord or seller to ensure they are in compliance with these rules. Second, it also adds source of income as another protected class. Discrimination based on an applicant's source of income is one of the most blatant and common forms of discrimination a person will face while seeking housing. Anyone who has looked for an apartment on Craigslist or any other rental apartment searching website is familiar with the phrase "no Section 8" or "no vouchers accepted." If you're not familiar with these programs, you may not have taken note of what this means, but it is the landlord saying they will not rent to anyone who is receiving rental assistance based on their income. There are many different types of these programs. Some are offered by churches, nonprofits, and some are administered by the federal government. By far, the largest rental voucher programs are administered by the Federal Department of Housing and Urban Affairs and the Veterans Association. For instance, HUD-VASH vouchers is the Veterans Affairs Supporting Housing Voucher. This voucher guarantees rental assistance for homeless veterans and provides them with case management and clinical services provided by the Department of Veterans Affairs. An eligible recipient can find a private apartment and will pay no more than 30% of their income on rent. The VASH voucher will guarantee the landlord the remainder of the rent. Right now, it is legal for a property owner to deny that veteran's rental application based solely on the source of payment and not the applicant's rental history, criminal background, or any other relevant risk factors. Protecting an applicant from discrimination based on their source of income does not mean that every landlord is required to rent to every voucher holder who applies for an apartment. This simply means that a veteran with a voucher be evaluated by the same standards as any other prospective tenant when they are looking for an apartment. They are not asking for special treatment, simply equal treatment. I bring this bill for the simple yet important reason. It is the right thing to do. People have a basic right to housing or an assurance that they may live in a safe and secure home free from discrimination and hate. It is our obligation as policymakers to make sure that everyone can enjoy this basic assurance. Thank you for your time, and I'm happy to take any questions.
Thank you, Senator Kavanaugh. Appreciate your bringing this bill. Any questions? Senator Brandt.
Thank you, Senator Kavanaugh. I guess I'm a little confused. On the amendment on citizenship status, what did that change from the bill?
It added it. That wasn't in the original bill.
Oh.
That wasn't in the green copy.
Okay, so this bill says then a landlord cannot ask about citizenship status?
They would have to require the same documentation for every applicant. So if they require documentation for identification documentation, it has to be the same for every person who applies. So they can't just ask, what country are you from? And are you...
Would a driver's license serve as qualification of citizenship?
I'm not sure that it would.
I
believe that our DACA students can have a driver's license, so it doesn't indicate citizenship status.
If the individual is not a legal citizen of the United States, would they be obligated to rent to them?
So they wouldn't be obligated to rent to them. They would be obligated to not ask them that question.
Okay, thank you.
Thank you. Any other questions? Nope. And will you stay here to close?
Yes.
Thank you,
Thank you.
Senator Kavanaugh. Okay, proponents. Oh, and do we have a count of how many people are here to testify on this bill, please? Okay, thank you very much. Welcome.
Thank you, Senator Pansing Brooks and members of the committee. My name is Abby Swatsworth, ABBISWATSWORTH. I am the Executive Director of Out Nebraska. Nebraska is a statewide organization working to empower and celebrate lesbian, gay, bisexual, transgender, and queer questioning communities. Out Nebraska stands in strong support of LB 689. 22 states and Washington, D.C. have legislation in place to protect LGBTQ people from housing discrimination. It is time for Nebraska to join this number. Protecting people from discrimination is simply about treating others as we want to be treated ourselves. LGBTQ Nebraskans want to provide for their families, and stable housing is a key element in family life. In a 2015 survey, 73% of LGBTQ Americans reported being strongly concerned about housing discriminations from agents, landlords, and neighbors. I've known multiple people who have experienced housing discrimination. In one case, a lesbian couple was forced to move from their longtime rental when the building was sold. The new owner told them that he did not rent to, quote, their kind. He threatened eviction if they did not vacate. Not wanting to mar their rental record, the couple were forced from their home and the neighborhood they loved. While most realtors, landlords, and management companies want to do the right thing, there will always be a few who will only do what's right when the law requires it. For those times when good judgment breaks down, we need laws so that all people, including those who are gay or transgender, have equal access to housing. Discrimination threatens not only access to housing, but the stability of communities. Members of the LGBTQ community are more likely to become homeless, and once homeless, more likely to endure discrimination and harassment that extends their homelessness. In a survey of transgender Americans, 1 in 5 report having been homeless as a result of their gender identity. No one should be refused access to housing, be forced to vacate current housing, or become homeless because of who they are or who they love. Finally, LGBT community members can also be members of immigrant and refugee communities. For this reason, and because it is the right thing to do, Out Nebraska fully supports housing protection on the basis of citizenship. We encourage you to advance LB 689. I'm happy to take questions.
Thank you, Ms. Swatsworth. Any questions?
Thanks.
I appreciate your coming today.
Thank you.
Next proponent. Welcome.
Hi, my name is Isabel Salas, and I'm a community organizer at the South of Downtown Community Development Organization, and I'm here today as part of Collective Impact Lincoln, a partnership between South of Downtown CDO, Nebraska Appleseed, and Civic Nebraska. The purpose of CIL is to be present in
Could you spell your name?
Sorry, ISABELSALAS. The purpose of CIL is to be present in 6 low-income neighborhoods in Lincoln in order to listen to residents' concerns, give residents the tools and opportunities to take action, and support policy change responsive to their needs. Through this initiative, I knocked on the door of Denise Dickinson, a resident living on the 900 block of D Street in Lincoln in District 27. She's asked me to read this letter into the record in support of LB 689 in the hopes of that sharing her story can help Nebraskans just like her achieve housing equality. Dear members of the Judiciary Committee, My name is Denise Dickinson, and I'm writing in support of LB 689 introduced by Senator Kavanaugh to add sexual orientation, gender identity, and citizenship status to the list of protected classes in real estate and leases. I'm especially supportive of Amendment 295 to add source of income to these protected classes. I'm a recipient of a Section 8 voucher to assist my income, and I know firsthand how difficult it is to be able to receive and even use a Section 8 voucher. I want to share my story for the greater good so that people in my situation won't be stigmatized when they're looking for a place to live. Many property owners and landlords have a bias against Section 8 recipients. I had to attend classes about being a responsible tenant and was on the housing wait list for 2 years before I even got my voucher. 2 years is an extremely long time to wait to even get benefits, and even then there was no guarantee that I would find a place that accepts my assistance. During that period, I lived in slum housing just across the street from where I live now because I couldn't afford anything else. I expected my housing assistance to improve my situation right away, but even when I got the voucher, I had to wait while my landlord considered whether or not they even wanted a Section 8 tenant in their unit, even after jumping through the hoops to get assistance. I am not alone, and many tenants in my situation face this challenge too. Fortunately, my landlord right now is great. He works to fix anything before the yearly housing inspection, which guarantees that my home is a safe and healthy place to live. Because of my housing voucher and my landlord, I don't have to live in slum housing. However, I know a lot of people aren't as lucky as I am to find a place that accepts housing vouchers. Right now, many Section 8 recipients have to return their Section 8 vouchers because they can't even find a place that accepts them. I am on disability assistance as well, and being able to use my Section 8 benefits gives me the ability to live in a community I love. I believe landlords shouldn't be able to discriminate against people in my situation simply because their source of income. I'm happy to share my story in support of LB 689 and Amendment 295, which will work for the greater good of our communities, so people can have access to healthy, affordable housing options.
Thank you, Ms. Salas. We're grateful you're here. Any questions? No, thank you very much.
Thank you.
Next proponent.
You need these ones.
Welcome.
Hello, members of the Judiciary Committee. My name is Dr. Erin Feichtinger, ERINFEICHTINGER, and don't worry, by the end of today you will all know how to spell it. I coordinate community outreach and advocacy at Together, which is a social service agency that has served Omaha for 44 years. Our mission is to prevent and end homelessness in our community, and for this reason we support LB 689, updating the non-discrimination language in the Nebraska Fair Housing Act. Our goal is an ambitious one, and it requires a holistic and comprehensive view of the causes of homelessness. Last year, we helped 25 individuals and 41 families transition from homelessness to housing through our Horizons program, which provides intensive case management to our clients, helping them find and keep stable housing. So this means providing financial assistance, education on reading and understanding a lease, their rights and their responsibilities as renters, and budgeting for rent and utilities. Additionally, our front door diversion program had over 500 meetings with people facing the immediate prospect of homelessness, helping connect them to necessary resources. So our team of case managers understands better than most the barriers to housing faced by low-income members of our community. We are also painfully familiar with the long-term causes and consequences of homelessness, some of which are gender identity, sexual orientation, and citizenship status. As an organization, we are dedicated to dignity and compassion for every member of our community who comes to us for help. We are similarly committed to being a safe space for the LGBTQIA+ community and our brothers and sisters who may or may not be citizens. None of these identities negates their need for food, housing, and sympathy. As for Senator Kavanaugh's amendment, this is another one we're painfully familiar with. Discrimination against source of income most often applies in cases where our clients receive Section 8 or housing choice vouchers from a public housing agency or any sort of public assistance as their primary form of income. This discrimination results in a very long wait list for an available unit and therefore a longer time in a homeless shelter or on the streets. It also means another unnecessary barrier to stable housing for our most vulnerable citizens. The addition of these classifications in the non-discrimination language is a reflection of how far we have come in recognizing the necessity of fair housing for all. We support this effort, reducing barriers to access for those we serve, and I am available for any questions that you might have.
Thank you, Ms. Feichtger.
You're going to get it by the end of the day, I promise. I'll be here again.
Feichtger. Okay. Any questions? No. Thank you very much for coming today. Next, Senator Conrad.
Hi, good afternoon.
Good afternoon. Welcome.
Thank you, and happy Friday. Hi, my name is Danielle Conrad. It's D-A-N-I-E-L-L-E, Conrad, C-O-N-R-A-D, and I'm here today on behalf of the ACLU of Nebraska. Initially, we'd like to thank the committee for their time and consideration of this important matter, and we'd like to thank Senator Kavanaugh for her leadership in bringing forward this important legislation. We're passing around some written testimony, so I'll just hit the high points so that not to take up too much of your time standing between you and your weekend and the other important bills on your agenda today. But housing discrimination laws that protect LGBTQ people from being unfairly evicted, denied housing, or refused the ability to rent or buy housing on the basis of their sexual orientation and gender identity are important. Think for just a moment about when you conclude your workday today and as you head home, to the sanctity, to the security, to the comfort of your home, and how important that is to your life and to your family's life. And imagine the instability that comes if you're denied access to safe and stable housing based simply on who you are and who you love. So the reality is that we know LGBTQ Nebraskans are discriminated against in the basis of housing. We know that from the studies, and we also know that anecdotally through our legal intake assistants at the ACLU of Nebraska. From a policy consideration, I also want to make sure to draw the committee's attention to a very recent public opinion poll that was conducted by the University of Nebraska, which specifically asked Nebraskans how they felt about housing discrimination on the basis of sexual orientation and gender identity. And an impressive 72% of Nebraskans, let me repeat that, 72% of Nebraskans from across the state and across the political spectrum support laws protecting lesbians, gays, and bisexuals from housing discrimination. So not only would you be on the right side of history, you stand in support with your fellow Nebraskans. Let me just say a few words about some of the legal issues implicated in this legislation, and I'm going to focus primarily on LGBTQ issues. I know one of my friends who's an immigration law expert is right behind me here today, but it's important to note that there is no federal law that specifically provides protection on the basis of sexual orientation or gender identity in the housing market. There have been strong rulings and considerations by HUD acknowledging that on the existing basis of sex or gender, and there is an emerging consensus in the federal courts finding the same. However, it is important to note there is no specific case law on point in Nebraska state courts, and there is a very recent adverse ruling from the 8th Circuit that implicates these issues and that necessitates a strong, clear ruling in support of equal rights in housing. So with that, we'd be happy to answer any questions, and we thank you for your time.
Thank you, Senator Conrad. Any questions? Okay, I do have a question.
Yes.
I'm so grateful for the work that you do, and you know that we've had other cases on LGBT
That's right.
people, and actually one's about to come up on the floor next week.
That's right.
And so can you talk about the fact why this is not special rights for LGBTQ people or special, because that's some of what we're hearing. This is not an attempt to give any group special rights. Is that correct?
I think that's exactly right, Senator Pansing-Brooks, and we thank you for your leadership on these issues. What LB 627 is about, your legislation in regards to employment non-discrimination, what Senator Kavanaugh's legislation, LB 689, is about, and other provisions that are for this legislature this session are about equality, are about fairness, are being treated as we would want to be treated. It's about ensuring equal footing and dismantling oppression and discrimination, which not only hurts the people that are being discriminated against, but which hurts us all.
Thank you. And also, could you speak just briefly on this case? In this case, do you foresee innumerable lawsuits coming because of this? Because that's the other argument we keep hearing.
Sure. And I think, thank you, Senator Pansing-Brooks, for the question. And, you know, it's important that we have all of the perspectives be a part of the debate, but it's also important to note that these debates are not happening in a vacuum, but in fact within the context of history. And that frequently we hear this kind of slippery slope argument that if we pass this kind of legislation in the employment or the housing context, that it's going to open up the floodgates for litigation, which is, of course, costly, lengthy, and uncertain, and while a powerful tool, sometimes a very costly tool to resolve our differences in a democracy. So we can look at the experience of our sister states. We can look at the experience of communities that have already updated their laws in a common sense, no cost way, just like 689 and 627 does. And you can find that the facts just don't bear that out. What happens after communities update their laws is that it provides a clear, bright line rule for all stakeholders, employers, employees, landlords, tenants, to know what the rules are and to ensure that everybody is abiding by them with clarity. And typically then what happens, the process is really good at ferreting out frivolous litigation, as it is in other contexts. And so I have strong confidence that that would be the same if 689 or 627 were to pass, and I hope they do.
Thank you. And just one more thing. Would this law stop a landlord from being able to evict a tenant who was either causing huge messes or breaking things within the and causing damage? Could you speak to that? Again, this is a special rights question, but again, I just want to clarify for the record.
Sure. Well, thank you so much again for that question. And I think that is an important reminder as you take up this legislation or look at these issues in the employment context. These laws don't vitiate common sense or our statutory and legal framework otherwise. For example, in the employment context, of course, you know Nebraska is a right-to-work state, right? So what that means is that employers can make a decision about who to hire or fire based on any number of reasons, as long as they're not reasons that are grounded in discrimination. The same would apply here in the housing context. The normal rights, responsibilities, and obligations that go into the housing context continue to bear in this context. It just ensures and ferrets out impermissible discrimination that hurts us all.
Thank you very much, Senator Conrad. Any other questions?
Thank you so much for your time.
Thank you for coming today. Next proponent. Welcome.
Thank you. My name is Alexis Steele, ALEXISSTEELE. Dear committee, I am the policy staff attorney for the Immigrant Legal Center, a nonprofit law firm that serves clients across Nebraska. I am testifying on behalf of our firm today in support of Legislative Bill 689. The Immigrant Legal Center supports this bill because it expands prohibited forms of discrimination in sale or lease of property to appropriately include identity characteristics inextricably tied to human dignity. LB 689 is a remarkably straightforward bill. It proposes to prohibit discrimination on the basis of sexual orientation, gender identity, and citizenship status. These bases of discrimination would join already prohibited bases of discrimination: color, race, religion, national origin, handicap, family status, and sex. Collectively, each of these designations is either an immutable characteristic, such as race or sexual orientation, or one that is technically mutable, but that our law recognizes would be wrong to be forced to change for equal treatment, such as familial status or citizenship status. And it is important not to lose sight that citizenship status is not a binary. Immigration status is not a binary. One may be discriminated against on the basis of being a lawful permanent resident versus being a citizen without this bill. While these characteristics are fundamental to identity, they have no bearing on a seller's or lessor's logical analysis of an individual's suitability as a possible purchaser or renter. This is why the Immigrant Legal Center supports this bill and urges each senator on the committee to vote in its favor. We take great pride and responsibility in supporting measures to make and keep our state a fair, non-discriminatory land. As advocates for people who have fled their nations for lack of protections and fair treatment on the basis of each of the characteristics proposed to be protected in this bill, we have an extremely detailed and strong appreciation for and take great honor in supporting LB 689 today. As an affiliate of the Justice for Our Neighbors Network, I move to end with a quote, "Love your neighbor as yourself." Mark 12:31. Not love your neighbor if he is like yourself, but as yourself, however he, she, or they may be. As many parents quote this to their children to urge them to treat others fairly and kindness, especially when a child would not want to, this bill justly requires just that. Fair treatment, but in accordance with the law where proverbial kindness fails. I welcome any questions and thank you for your consideration.
Thank you very much. Any questions? I just have one. Thank you for coming today. I was wondering about your discussion of the mutable and immutable characteristics. Is that pursuant to Supreme Court dicta, or how is that? Is this a theory that's come up? I'm just interested because I hadn't really.
Absolutely. When referring to those immutable characteristics, I'm referring to civil rights protections that recognize that characteristics such as race, color, religion, and the list goes on, how those are fundamental to identity, fundamental to human dignity, and either cannot be changed because they simply are facts of existence, or should not be forced to change for equal treatment.
And have there been cases on this? That's why I was wondering if those language.
There have been cases in the context of employment discrimination, as well as housing, and those cases include those that are established and protected under federal laws.
Wonderful. If you could get some of those cases to the committee, I think we'd be very interested in that.
Absolutely, I will do that.
Thank you very much. Thank you for coming today.
Thank you.
Steele. No other questions? Any further proponents? Proponents? Okay, what about opponents? And pardon me? Proponents, yes, Welcome.
Hello, my name is Ella Durham, ELLADURHAM. My son is almost 16 and, of course, daydreaming about his first apartment. You would think that my conversations with him about this would be about what to expect financially, how exciting it is to have your very own place for the first time, and how to start preparing for that independence. And yes, while we do have these conversations, they're always secondary to another reality that I have to prepare him for. My son is queer and trans, and he can be legally discriminated against because of this in the state of Nebraska. I talked to him about how those suffering from housing discrimination are often forced into small or low quality housing, that housing discrimination contributes to residential segregation and is a barrier to home ownership, both leading to generational wealth disparities. I actually encourage him and urge him to consider moving to another state where he would be more protected. For example, Colorado, Iowa, Minnesota, or Illinois. I know this firsthand because I am queer and I have had to navigate my identity to protect myself and my child against housing discrimination. If I weren't tied to Nebraska under a set of personal circumstances, I would have moved away long ago because of the lack of protections in Nebraska. As I have argued in regards to workplace protections for the LGBTQ plus community, Nebraska loses some of its best and brightest young people because they can see they are not valued and protected under Nebraska law. 1 in 5 millennials identify as LGBTQ+, and only 66% of young people today identify as exclusively heterosexual. Housing discrimination based on sexual identity or gender expression would be wrong if it were only one person, but how can we allow this for such a significant portion of our community? Even though we face these issues directly, we carry quite a bit of privilege being white, and by me having the socioeconomic mobility to have pulled us out of poverty and even be considered middle class now. With that, I have to honestly say I'm less worried about myself or my son being able to secure housing than I am for someone whose citizenship status is in question. I can only imagine how compounded these issues become for immigrants or refugees. No person should face housing discrimination based on their sexual orientation, gender expression, or citizenship status. LB 689 is only the right thing to do and just one small but critical step in dismantling the systematic oppression of these people in our state. Nebraska touts itself as a state with family values. Let's put our policy where our mouth is and show families of all backgrounds are valued. Thank you.
Thank you very much for coming, Ms. Durham. Any questions? No, thank you for your courage to come forward. Any further proponents? Okay, we'll now switch to opponents. And if you could, yes? Yeah, opponents, and if you could please come down, those of you who are opponents, if you could come into the first row so that we can keep things moving along here, that would be great. Thank you. Welcome.
Hi, my name is Don Pearson, and I actually didn't arrive today to give testimony on this particular bill, but as I listened to it, I'm in support of the LGBT section of the bill, but when I hear the concept about income discrimination, I wanted to let you know that all issues are not centered around discrimination. And as a business owner, rental property owner, when I first got into the business, I had a family approach me about renting a house. I thought they'd be fantastic. And then they said, well, we're on Section 8. Well, I hadn't experienced Section 8, so I contacted them, let them know I had an application from this family, and they came out and inspected my building. So I have 100-year-old buildings in the downtown area. Their inspections are far more rigorous than even the building and safety inspection regiments. I was eager to rent to the family, but when the list of things came back that I needed to fix, holes in screens, as a 110-year-old building, one of the floors weren't level, it would cost me thousands and thousands of dollars to bring my building up to code so that I could rent to them. So I elected from that point on not to deal with Section 8. As you can imagine, as a business owner, rental owner, I want to rent to the largest piece of pie that I possibly can. There's a lot of people that I'm going to weed out, felons, crackheads, and so forth, but I want to keep the pie as large as possible. With that said, I'd like to rent to Section 8, but it would cost me a lot of time, money, and effort, in addition to what I already do for the building and safety requirements, where I get inspected once a year with them. This would add an extra layer of inspections. So that's why, again, I support the LGBT section of the bill, but income discrimination and the concept of discrimination itself is not always the central of people like myself's opposition to this kind of bill. So there are business decisions invoked with that.
Thank you, Mr. Pearson. Any questions for Mr. Pearson? Nope. Thank you very much. Next opponent. Welcome.
Larry, excuse me. Larry Store, 5015 Lafayette Avenue. That's spelled S-T-O-R-E-R, District 8. Once again, we're really talking about constitutional issues here. I'm going to start off with life, liberty, and pursuit of happiness. Mine. Freedom of speech. Mine. due process, mine. Equal access under the law and protection, mine. My freedoms are being restricted in favor of certain classes of people. Now, I am a taxpayer, I am a property owner, single-family household, but you're telling me in this bill that I don't dare rent out a room in my house to somebody in order to pay my property taxes, which are getting pretty hard to pay because of things like this. But I also want to read some of your own state constitution here from Article 3, Section 18. Local or special laws are prohibited. But if you read clear back to the end, granting any corporation, association, or individual or group, if you read it, the intent, the right to, et cetera, et cetera, et cetera. They have exclusive privileges, immunity, or franchise whatsoever. And skip down a little further, all other cases where a general law can be made applicable, no special law shall be made. Are you telling me that the Constitution of the United States is not a general law for all of us to follow? What about the oath of your office? The oath of your office on page 69 of your own journal holds you accountable for not having give any special interest or privilege or recognition to any particular group. I'm sorry, but my life, liberty, and happiness is being restricted by special groups that are asking for your special attention. I think the Constitution is clear. I'm not supposed to discriminate. You don't have to tell me on what. We've got so many alphabet letters now and so many Section 8s, 5s, 4s, 321s that I'm afraid to ask anybody anything. I'm afraid to look at anybody. I'm afraid to rent my room out to help me pay my property taxes because somebody will make an assumption, run downtown and file a complaint, whether it's valid or not. Within 6 months, I'm a convicted felon or whatever. Excuse me? That's not right. Thank you.
Mr. Storr, any questions? Nope, seeing none. Next opponent. Thank you. Welcome. Welcome.
Good afternoon. Thank you. My name's John Dockery, and I live in Omaha. I'm retired from surgical medical sales.
Could you please spell your name?
It's Johndockery.
Thank you.
15 years ago, I bought 4 rental properties as an investment, which I have managed myself. And there's a lot of other people in the state that are just small investors just like me. I've always enjoyed working with people and take pride in the rental properties and the relationships with those who live there. I'm opposed to LB 689 to add gender identity, sexual orientation, and citizenship status to our current list of non-discriminatory classes. I've learned through experience to be as objective as possible when picking new tenants. I've rented to many types of people, singles, couples, and families, and I've never had anyone offer their sexual orientation or gender identity, or would I ever ask. As far as citizenship status, I've never had a problem. I've rented to legal immigrants before, and they went through the same application process and are evaluated in the same way. What I look for in a prospect is primarily if they will pay the rent and take care of the property. Everyone fills out a standard lease application. I call employers, former landlords, and personal references to identify their ability to pay the rent and take care of the property. One's sexual orientation, gender identity, or even citizenship status is not on my application. One of the ways that our current law protects them is the class creed, which is listed in the first references of the present non-discriminatory classes. My suggestion is to add creed to all of the other lists in our state real estate laws. Thank you.
Thank you, Mr. Dockery. Any questions? Seeing none, thank you. Next opponent. Welcome.
Hello. My name is Marilyn Asher, Marilyn Asher. I am recently retired from the state of Nebraska as an employee. My husband and I are supplementing our retirement income through rentals. And I would just like to read a portion of the Nebraska Conscience Clause, Article 1, Section 4 of the Constitution of the State of Nebraska. All persons have a natural and indefeasible right to worship Almighty God according to the dictates of their own consciences, nor shall any interference of the rights of conscience be permitted. As a landlord, and I am also a landlord with my siblings, I find LB 689 is about forced participation. I'm opposed to LB 689 because it forces me to possibly rent to an illegal non-citizen. That would be, and I could be accused of criminal conduct. We are in effect opening our doors as a sanctuary to people who are not legal citizens. I am not opposed to non-citizens who are legal, but very opposed to those who are not and do not, in good conscience, feel that we can rent to them. Thank you.
Thank you, Ms. Asher. Any questions? Seeing none, thank you. Next opponent.
Thank you.
Welcome.
Good afternoon, Senator Pansing Brooks and other members of the Judiciary Committee. My name is John Chatelain, John, last name Chatelain, and I'm speaking on behalf of the Metropolitan Omaha Property Owners Association. And the comments I make are on behalf of the association, not my own personal views. But Metropolitan Omaha Property Owners Association is an association of about 500 members that all own rental properties in the Metropolitan Omaha area. And we also affiliate through the statewide Property Owners Association with the Real Estate Owners and Managers Association in Lincoln and the Gage County Landlord Association in Beatrice and other groups across the state, primarily for lobbying purposes. And we speak on this bill just very generally. Our association in no way would advocate discrimination against people based on their sexual orientation or their gender identity. I'm not so enthused, however, about adding more classifications of people who could sue the landlord if they were not rented to or if their lease was terminated, having nothing whatsoever to do with those protected classes. Specifically, I want to speak against the amendment. I believe there is a proposed amendment to 689 that would add source of income as a protected class, specifically Section 8. My wife and I have rental properties. We rent properties Section 8, and we rent properties without Section 8. But we make a conscious decision to go with Section 8 if we do so. And like Mr. Pearson said, there is indeed a lot more work involved if you make that decision to go with Section 8. And I don't believe that we should be meddling in the business of the landlord to that extent where we would insist that they take Section 8. And I speak on behalf of our association on that point. So specifically, we would reject or oppose the proposed amendment.
Thank you. Thank you for coming, Mr. Chatelain. Any questions? No questions, thank you.
Okay, thank you.
Next opponent. Welcome.
Good afternoon, Senator Pansing Brooks and members of the Judiciary Committee. My name is Gene Eckel, that's Geneckel, and I'm a board member for the Nebraska Association of Commercial Property Owners and the Apartment Association of Nebraska. Our intent here was to support this bill, but after hearing of the amendment by Senator Kavanaugh, we're now being switched over to oppose that portion of it. We do support the original legislation. It mirrors the protection already set forth by HUD's final rule in 2012, and our members typically don't even ask about citizenship, so we don't have any issue with that. With regard to the source of income, though, we do. We really don't believe that's the intent of Congress when they passed the Fair Housing Act. And a lot of times the entities that are paying the subsidized portion are slow, and that affects the landlord's business process and business model. It also requires the owners and operators to adhere to additional requirements, what I believe you just heard from another person who testified in opposition. It forces the landlord or the management company to use a local public housing agency's model lease instead of their own. It requires them to enter into housing assistant payments contracts with an agency, which also has added administrative responsibilities. It makes limitation on increases and subject to approval by the agency of those increases in rent. And there is the potential of delay in rental payments of any point without recourse due to federal budget appropriation delays. With that, we'd just like to ask the committee to support the original legislation but oppose the amended portion, and I'd be happy to answer any questions.
Thank you for coming, Mr. Eckel. Any questions? Nope. Thank you very much.
Thank you.
Next opponent. Welcome.
My name is Scott Hoffman. Last name spelled Hoffman, first name Scott, Scott. I wasn't going to challenge this bill, but I'm kind of between opponent and neutral. I've been renting property for almost 35 years, and in those 35 years, I've dealt with hundreds of tenants. And I've only had to evict 5 people, and they were wicked evictions. I mean, they were literally deadbeats. They knew the law. It takes 10 to 14 days right now to trial, and the judges usually set the court dates for 14 days to evict people. But I wanted, Senator Brandt brought up about as far as identifying people. When we run an application, the primary thing that we're going to need is a social security number. So if somebody's new to this country, they don't have a social security number, that's going to be difficult to run an application. Our organization that we use, we can contact them and make some exceptions to the rule, but obviously we got to treat everybody equally, and we've got to know these people's backgrounds. How long they've been in the country would be another issue. Currently, right now, I rent to somebody from the Congo. They filled out an application. It was remarkable. I rented to them. It wasn't a problem. So, but I just wanted to address that. I mean, as far as the income issue, I don't know. That is a federal level. It's not state. It's not city. I don't know if everybody's aware of this, but that's why I don't do housing, because they don't pay for damages. I don't know if you knew that or not. Oh, let me repeat that. Housing does not pay for damages. You have to rely on the indigent person that's getting housing assistance to begin with to rely on them paying the damages. And if you think it's going to be 1 month's rent, you're sadly mistaken. Usually evictions run close to about $3,000. That's what the last one cost me, between attorney fees, cleaning the property up, and leaving it empty. So again, I'm against the amendment on the income issue, and then trying to explain exactly why we have to run the applications. The 30% is kind of redundant. We actually require 40%. We have to bring that up a little bit. Recently, I had a lot of my properties reevaluated with the county assessor. Omaha and Lincoln's doing that. and they skyrocketed. I mean, I literally will have to raise my rents $100 a month just to cover the taxes. I mean, it went up hundreds of thousands of dollars. So that is an issue as far as us trying to maintain our properties and make affordable housing. That's it. We live in a state, and you know, Senator, that property tax issue is a very big issue, and it is as for us as landlords. So that's it. Any questions?
Thank you. Thank you for coming, Mr. Hoffman. Any questions? Nope.
Thank you.
Thank you very much. Any additional opponents? And please come down if you can so that we can keep this going. Welcome.
Thank you. Senator Brooks, members of the Judiciary Committee. My name is Samuel Lyon, Samuel-Lyon. I have been a landlord for about 15 years, bought my first property 15 years ago, and have several here in Lincoln. Also have enjoyed leasing those out to many citizens of the Nebraska. People who live here, work here, enjoy the state. I love working with people. I love interacting with them. I don't enjoy everything that they do and all the ways that they take care of the building or the property. But I do enjoy working through things and talking with them about those things. I think what a lot of this comes down to is, for us landlords, the property that we have is our investment. It is our 401k, if you will. And every time we rent it to someone, we put that at risk. The people that come into it, if they damage it, if they destroy things, if they consume them, it's generally not them that are going to fork out the $3,000 to $5,000 to rehab that property. It's us. And just as sometimes in the previous years, your 401ks have got a $5,000 or $10,000 hit. It hurts, and it hurts us when our properties get a $4,000 to $5,000 hit. I also have never had anyone volunteer to me what their sexual orientation is, or most of the time whether they're married, how many, really anything, and I don't ask. But I do care very much about how well they'll take care of the property, how many times the police are going to get called out to that property, and if they're going to pay their rent. Those are kind of the three things that I look at mostly. And I pull a credit check, I do a background check, and I interact with them and I ask them questions. And I try to base my decisions on whether I'm going to rent to them, on whether we're going to have a good interaction and they're going to take care of the property and pay the rent, or if they're not. As far as the Section 8, I have accepted Section 8 for about 5 years of my 15 years. I haven't for about 7 years. One of the reasons is that Section 8 themselves discriminate. They discriminate based upon a screen that's torn, a hole in the side of a drywall that's bigger than the size of a quarter. And even if you've passed all the inspections, which mine have, and if the tenants take out one of the screens, one of the kids takes out one of the screens and loses it, or pulls the refrigerator shelf out, the Section 8, when they come in to inspect it, will say, I have to fix that. And if I don't, their only method of making me fix it or making the tenants do what they need to do is to pull the money. And so as a source of income, that's very important to me, is to know that that person's source of income is going to continue. And so what Section 8 says is, if we catch somebody that's in there that's not supposed to be there, like a boyfriend or someone, or if the housing doesn't meet its inspection, we will pull the housing from you. And now I have someone in my housing that obviously can't afford it. So would be very opposed to those, and for those reasons I oppose this bill.
Thank you, Mr. Lyon. Any questions for Mr. Lyon? Seeing none, thank you for coming.
Thank you.
Any additional opponents? What about people in the neutral? Welcome.
Thank you, Vice Chair, and thank you, Senators. My name is Ben Watson. That's BenWatson. I am the Housing Investigations Unit Director for the Nebraska Equal Opportunity Commission. I appear here today to testify in a neutral capacity on this bill as a representative of the Commission. The NEOC is a state agency that investigates discrimination claims. We have direct oversight in carrying out the provisions of the Nebraska Fair Housing Act. This year marks the 50th anniversary of that state act. The NEOC operates in part through a work-share agreement with the U.S. Department of Housing and Urban Development. Because of this agreement and because of the state and federal Fair Housing Acts are substantially equivalent, we rely on federal guidance and interpretation to inform our work. While I am here to testify in a neutral capacity, it is fair to say that the NEOC is generally in favor of legislation that makes housing more fair and inclusive for more people, and such legislation helps us fulfill our mission of eliminating discrimination in the state. Both the federal and state fair housing laws include protections on the basis of sex. Per HUD guidance, the NEOC already processes housing claims based on sexual orientation and gender identity under sex discrimination. Last year, the NEOC processed 3 housing cases involving sexual orientation under sex discrimination. Separating out sexual orientation and gender identity as their own protected classes would encourage more individuals to come forward and also lead to more thorough and precise investigations. It will also clarify and improve the law for housing providers who often do not know that sexual orientation is included in sex discrimination. In 2012, HUD enacted a final rule in response to concerns over LGBT individuals and families being denied housing in their programs. The rule notes that, quote, it is important not only that HUD ensure that its own programs do not involve arbitrary discrimination, but that its policies and programs serve as models for equal housing opportunity, end quote. Because of this final rule, a person living in or applying for public housing in Nebraska or a person using a housing choice voucher, formerly known as Section 8, is protected right now from sexual orientation and gender identity discrimination by this final rule. It likely makes sense for the legislature to provide the same protection to all Nebraskans, to those that who are not living in public housing and not using vouchers are not less protected than those Nebraskans who do live in public housing or use vouchers or use HUD-backed mortgages. In regards to citizenship, we can state that despite our neutral stance, we are generally in favor of expanding protections under the law to new groups. As part of a neutral stance, though, the NEOC does feel it is important to note that at least 2 communities exist in Nebraska where local ordinances may be in conflict with this new protected class. If this bill becomes law, the NEOC, and thus by extension the state government, may be pulled into a potential legal conflict with those communities. Fiscally, while we anticipate this bill becoming law would create an increased number of complaints filed with the NEOC, we believe our current staffing and budget can absorb that increase. Regardless, we do not feel we would be in a position to measure the exact effect until fiscal year 21-22. I'm available for questions. If I may suggest, as the Unit Director of Housing Investigations, if anyone specifically has any questions about how we would investigate or enforce these new sections, I'd be happy to answer those or anything else.
Thank you. I guess I'd like to hear how you do investigate it, since you're offering.
Sure.
Mr. Watson.
From what I understand and from what I've read in this bill, this would just add protected classes to the bill, so we would enforce the law for these protected classes the same as we do the current ones, such as race and national origin. So if a person came to us and said they believed they were not rented an apartment because of their sexual orientation, we would then get that person to file a complaint, and then we would serve the landlord, and we would conduct an investigation and look into if sexual orientation was indeed the actual reason that person was not rented an apartment, or if there was a legitimate non-discriminatory reason, such as perhaps that person had a lower credit score, or that person had a bad background check. Their previous apartment they had left in shambles, and so they had a bad reference. And so if it turned out that the person who complained was actually the most qualified person to apply, that would indicate it most likely was sexual orientation that caused them to not get the apartment. Conversely, if they weren't qualified to rent in some way, or another tenant was more qualified because they had a better credit score, then that would indicate it was not discriminatory. That's just kind of the general process we go through for any of the protected classes in the law.
Okay, and also, I presume that you have been involved with equal opportunity commissions that are in various states, at least probably through meetings and other. So can you talk about the other states that have had these kinds of protections? Have there been additional multiple litigation? What kind of, I mean, we're hearing from some people that this could cause hundreds of cases to be all of a sudden filed. What's your thought on that?
Mm-hmm. Every state is different. I mean, I have heard that New York had, a large increase, but Colorado, I have not heard that there was a huge increase. There certainly would be an increase. Right now when somebody believes that they've been discriminated against and they look up their own state law and they look down the list of protected classes, if they don't see sexual orientation there or gender identity, then they go, oh, I'm not protected, and they don't call us. Even though they technically are under sex and they could call us, they don't know that. So, just looking down and seeing it, they would call. I don't have any specific statistics about other states, but it certainly would result in more complaints, I would think.
So do you have a stand on if there are more complaints that would indicate that there are problems out there?
Mm-hmm. Well, like I said, we do every year have people who do come to us and file based on sexual orientation under sex discrimination. We had 3 last fiscal year. That actually represented half of the housing complaints based on sex. There were 3 other sex discrimination cases in housing in front of the NEOC that were involved, I guess what I'd call regular sex discrimination, as opposed to based on sexual orientation. It's impossible to predict. Part of the problem is we do not track any statistics about people who call up and indicate things that aren't covered. We actually get a lot of calls from people who want to file a complaint saying they were discriminated against because they're smokers, or actually we do get some that call because of source of income, but we don't track those because they're not the protected classes in our laws. So we just mark those as did not have a valid complaint, basically. And so we do not have exact numbers to give you, unfortunately, on how many call for those other protected classes that we don't cover.
So has the NEOC ever thought of adding to whatever website that people are coming to and looking to see whether or not they are protected, something that indicates that they would be protected under sexual orientation or gender identity? Why, just under regulations or annotation? It seems like that could be on the website to be able to let people know that you will take their case and help them out.
I believe our current thought process is that it's not necessarily neutral to outright state that, but we do include links out to federal guidance that says such things. It's kind of awkward to investigate sexual orientation under sex because we don't actually investigate it as sexual orientation. We investigate it as a sort of, I'm trying to remember how it's exactly phrased. It's gender stereotyping or sex stereotyping. Basically, the legal theory is that we see if a landlord is discriminating against a possible renter or in sales based on the person not conforming to the typical behavior you'd expect from a male or a female, which would include dating a person of the opposite sex. So it's a very convoluted way of investigating it right now without sexual orientation or gender identity being added to the law explicitly. And so I think there is a presentation up on our website that explains this, but it's convoluted, and you have to get to it, and you have to kind of just go through to understand it. It certainly would be a lot simpler just to have those protected classes stated outright in the law.
Clearly, if the NEOC is confused and because they feel it's convoluted, there's a need for this to protect people who are being discriminated against, and so that people can understand their rights and not end up homeless or in another bad place. Thank you very much for coming.
Thank you.
Any other neutral testimony? Hey, Senator Kavanaugh, would you like to close?
Thank you, Vice Chairwoman and committee, for hearing my bill and everyone's testimony today. So I believe very firmly that housing is a human right, and that we should be doing everything that we possibly can to ensure that the citizens of Nebraska have access to quality, safe, affordable housing. This bill, like almost every single bill that I have brought this session, has personal ties for me. The vouchers piece, my uncle is a Vietnam War veteran, and he has a HUD-VASH voucher. He does not live here in Nebraska, but when we go and visit my mother's family, we go and visit his apartment, and it's not an amazing palatial place. It's a one-bedroom, just enough space for him to have a chair and a desk and his bedroom. But it suits him, and it's safe and it's clean. And so it's important to me to make sure that we're looking after our veterans and those that need financial assistance, and that they can access quality housing without discrimination because of their financial means. Former Senator Conrad's testimony about public opinion poll, and that 72% of Nebraskans believe that this should already be the state of things for the LGBT community. The testimony that we just heard from the previous gentleman about the complications right now, that they actually can pursue legal action for discrimination against the LGBT community, but it's convoluted. So this bill helps make that easier for everyone involved, makes the intent of the law clearer and more explicit. Country of origin, it's not a question that needs to be asked. It doesn't mean that you have to rent to somebody. It's just not something that we should be asking people where they're from or who they love. I love my aunt. She's an immigrant from Croatia. I love my cousin. She's gay. I love my uncle, and he has a HUD-VASH voucher. I love these people, and I think that all of these people deserve housing. They deserve safe and affordable housing. A good tenant is not based on gender identity or sexual orientation or citizenship or because of where their money comes from. I've been a homeowner for almost 5 years. So, as you all know, I turned 40 in January. That means I've rented a lot in my life. And I've had some really terrible roommates, and I've had some really terrible people live above me and below me. And they were white Nebraskans of means. It had nothing to do with their gender identity, their citizenship, or where their money came from. They were just bad tenants, and I'm sure everyone sitting behind me would come back up here and happily testify that they've had bad tenants of those persuasion. So it's not about asking anyone to rent to a bad tenant. That is not the purpose here. The purpose here is to not exclude people because of some ideological difference you may have with them. If they're a good tenant, you should take their business. And that's really the only intention here. I'd like to just leave the committee with one last thought. We heard Mark 12:31, love thy neighbor as yourself. I've been looking over a book that I shared with Senator Pansing Brooks, and it referenced something from the Catholic Catechism, and I am Catholic, and so I went and looked it up. It refers to how Catholics within the faith should interact with those within the faith who are in the LGBT community. And it says in the Catholic Catechism that they must be accepted with respect, compassion, and sensitivity. Every sign of unjust discrimination in their regard should be avoided. That is what drives me here today, and that is why I hope that you will move this forward to the floor. Thank you very much.
Thank you, Senator Kavanaugh. Any questions? Nope, seeing none. Thank you.
Thank you. Have a great weekend.
Thank you. Closes the hearing on LB 689. Let me see if there were any letters. Just one second. Okay. Here we go. There are letters, so if we could just wait 1 second. So we have 6 letters in support and 26 letters of opposition and 0 letters in the neutral. So that closes the hearing on LB 689. And now, welcome Senator Hansen. We will be opening the hearing on LB 395. Welcome.
Welcome, thank you. Good afternoon, Vice Chair Pansing Brooks and members of the Judiciary Committee. My name is Matt Hansen, M-A-T-T-H-A-N-S-E-N, and I represent District 26 in Northeast Lincoln. Since this is my first of 5 bills on landlord-tenant law, let me start with some background. Last year, I introduced a series of interim studies on affordable housings, neighborhoods, and rental issues. This is a direct result of many conversations I heard from my constituents as I represent a district and neighborhoods with a high rate of renters. 2 of those interim studies, LR 392 and LR 433, were scheduled for hearings by the Urban Affairs Committee, and we heard testimony in Omaha, Grand Island, and Ord. I was glad to have a chance to hear the issues regarding affordable housing and rental property in cities of different size across Nebraska. At all of these hearings, though, the continued focus of testifiers and advocates drifted toward issues related to landlord-tenant issues rather than neighborhood and municipal solutions for development and housing. It became clear to me that as a state, one area in which we can clearly help our constituents when dealing with access to housing is to update our landlord-tenant law. Following those hearings, my office worked with a variety of different stakeholders to identify current problems with the state's Landlord-Tenant Act. Following those conversations, we've come up with 5 proposals you will hear today. I chose to present these as 5 separate bills rather than as one package due to the fact that I think they represent all discrete issues deserving of focus and range from issues I would hope are consensus to ones I know are a larger ask. Moving forward, I will likely ask this committee to combine several of these bills, but for the moment, I just want to thank you for your patience in hearing these bills in a row today. These issues all came from different conversations with different advocates, and I think it is important to hear each on its own merits. With that, I will move on to the first bill we have here. LB 395 would prevent victims of domestic violence from being evicted if the reason they are being evicted stems from circumstances surrounding their abuse. For example, when the police are called as a result of an argument, under some circumstances, the landlord has the ability to end a lease and evict tenants regardless of who the instigator was. You'll see in the bill that there are 2 places that added language, with added language, and that is because there are currently 2 ways a tenant can be evicted in Nebraska that don't include non-payment of rent. The most common method landlords use is referred to as a 1430 notice, where if a tenant is failing to adequately maintain the unit or is breaking the lease somehow, they have 14 days to fix the problem, or else the landlord can start eviction proceedings. Additionally, in 2016, we passed into law a stricter type of eviction process where a landlord can end the lease and evict a tenant after 5 days' notice with no opportunity to tenant fix the problem if the tenant, member of their household, or guest engages in any violent criminal activity in the premises, the illegal sale of any controlled substance on the premises, or any other activity that threatens the health, safety of other tenants, the landlord, or the landlord's employees. LB 395 would prevent victims of domestic violence from being evicted under both methods. It is ultimately up to the judge in the eviction proceedings to decide if the grounds for the breach or noncompliance is the direct result of the tenant being a victim of domestic violence. These tenants are especially in need of this exception when it comes to the 5-day eviction notice, since the law states that criminal activity only needs to be committed by anyone with the tenant's permission to be on the premises. There is currently an exemption for those who seek a protection order, but forcing victims of domestic violence to get a protection order or else be subject to eviction is dangerous and undermines the victim's ability to decide what is in their best interest. Across the country, there have been several lawsuits challenging the constitutionality of ordinances that allow eviction of tenants when a crime occurs at their homes, even when they are victims. We need to ensure we are not leaving ourselves open to litigation, and more importantly, that our laws do not prevent victims of their neighbors from calling police when they are needed. For survivors of domestic violence, housing security and access to police assistance are essential for living free from abuse. We need to make sure our laws are tailored so that victims of crimes are not unfairly removed from their homes. With that, I'll end my opening and be happy to take any questions from the committee.
Thank you, Senator Hansen. Yes, Senator Brandt.
Thank you, Senator Hansen, for bringing this bill. Could you clarify for me, did you say we have a law in place now if the victim has a protection order?
If the eviction has a protection order, they are protected from one of the two types of evictions, yes.
So they would be protected from just one of the two?
Yes, that's my understanding.
Okay, thank you.
Of course.
Any other questions? Thank you, Senator Hansen.
Thank you.
Okay, we move to proponents. And how many people are here to speak on this bill specifically? Okay. So as we hope you would remember, if you don't have to use your entire time, and since these bills all do relate to each other, if you could just talk specifically about the part you love or do not care for, we would appreciate you moving along on this. Thank you. Okay, yes, please welcome.
Good afternoon, Senator Pansing Brooks and members of the Judiciary Committee. My name is Robert Sanford, R-O-B-E-R-T-S-A-N-F-O-R-D, and I am here today on behalf of the Nebraska Coalition to End Sexual and Domestic Violence in support of LB 395. Nebraska Revised Statute 76-1431 currently provides that a landlord can evict a tenant in certain circumstances with a 5-day notice. The activity that can lead to such an extreme result includes, but is not limited to, a physical assault or the threat of a physical assault, illegal use of a firearm or other weapon, or any other activity or threatened activity that threatens the health or safety of any person. The actions described above do not need to be the actions of the tenant. Section 5 of the law appears to provide protections from eviction for individuals who report the activity to police or seek a protection order. Unfortunately, this is not enough. As a society, we often believe that calling law enforcement or obtaining a protection order does in fact provide safety for victims and ends the abuse. However, far too often, I hear that victims fear contacting law enforcement. In fact, in some communities in Nebraska, victims with a protection order who contact law enforcement when a violation occurs are themselves arrested and charged with a crime simply because of the respondent's behavior. This creates a chilling effect that keeps victims from accessing law enforcement services or from obtaining a protection order in the first place. The relief that those in opposition to this bill will say is already in place in Section 5 of 76-1431 is non-existent for tenants victimized by violence in these communities. LB 395 adds to Section 5 of 76-1431 by stating that subsection 4 of the current law does not apply to victims of domestic assault. It is an attempt to ensure that victims of domestic violence, those who are already vulnerable in our society and unable to control the behavior of a partner who chooses to use abuse, and for whatever reason fear contacting law enforcement or seeking a protective order, do not need to fear being evicted for the behavior of their intimate partner. As a society, we often place blame on victims for the behavior of someone else choosing to use abuse. If only the victim would leave the relationship. If only the victim would get a protection order or call law enforcement. At the same time, we fail to provide the support to victims that is needed to overcome the abuse if they do not respond in the way we think they should. LB 395 is an important bill. It provides victims of abuse with additional important safeguards. The Coalition thanks Senator Hansen for taking up this issue, and we encourage you to advance LB 395. Thank you.
Thank you, Mr. Sanford. Any questions? Nope. Thank you very much for being
here.
Next proponent. Welcome.
Good afternoon, Senator Pansing Brooks, members of the Judiciary Committee. My name is Kristen McTaggart, first name C-H-R-I-S-T-O-N, last name is M-A-C-T-A-G-G-A-R-T. I'm the Domestic Sexual Violence Project Manager for the Women's Fund of Omaha, here to testify in support of LB 395. Survivors of intimate partner violence are 4 times more likely to experience housing instability than those not experiencing such violence. This is for a variety of reasons, but includes eviction due to lease violation as a direct result of violence. Nearly half of all homeless women report that their homelessness is the direct result of domestic violence experiences. This causes strain on our residential and shelter services where the need already exceeds the availability. Nationally, over 186,000 households leaving a relationship where there's abuse and attempting to enter a domestic violence shelter were unable to do so. Many states have already implemented laws to increase housing protections for domestic violence survivors. Those protections include the right to early termination of a lease for victims leaving an abusive relationship, exemption from eviction for lease violation relating to domestic violence incidents, and the right to have locks changed. As of 2017, Nebraska was one of 14 states that had yet to legislate any of these protections in this way. LB 395 will ensure that one of those, protecting survivors or providing survivors an exemption for eviction as the result of their abuse, is established. The current law, as referenced, states that a victim can be evicted within 5 days' notice for the from the rental property for damages or an assault on them by a partner, unless they file a protection order or report the activity to law enforcement. Giving a victim an arbitrary 5 days to meet requirements so they don't end up homeless puts all the responsibility on someone who's already in danger, who may still be in the hospital or recovering from injuries, and is dealing with the other impact of trauma and of a crime being committed against them. Also, engaging this system is a time of escalation for domestic violence victims, and it can be incredibly dangerous. Safety is in jeopardy, arrests are not always immediate, and protection orders are most definitely not guaranteed. Victims know what they need to do to stay safe, but current law mandates actions that can potentially put them in greater danger in order to avoid becoming homeless. Our current housing laws essentially hold victims responsible for their own abuse. LB 395 would extend support to survivors during those times, and as such, the Women's Fund respectfully urges the committee to support this bill and advance to general file. I'd be happy to take any questions if you have them.
No questions. Thank you so much. Next proponent.
Thank you.
Welcome.
Thank you. Good afternoon, Senator and members of the Judiciary Committee. My name is Scott Mertz, Scottmertz. I'm a managing attorney with Legal Aid of Nebraska. Now, Legal Aid of Nebraska is the only statewide organization, and has been the only statewide organization for over 50 years, that provides legal services and legal representation to low-income renters threatened by eviction. Our organization employs roughly 45 attorneys across 6 state offices. In 2018, Legal Aid in Nebraska closed over 12,000 cases, and among those, over 1,000 cases involved a tenant who had a legal issue in a rental housing. And in many of those cases, we are able to protect the tenant, preserve their housing, but often we are the ones who have to explain that under the law as currently written, there is little that one can do, and they must leave their homes, sometimes with their children in tow. And this is happening in an environment where there is a chronic shortage of affordable housing across Nebraska. Now, another priority for us at Legal Aid Nebraska is domestic violence. Domestic violence is a serious problem for low-income Nebraskans eligible for our services, and we try to ensure that any victim of domestic violence is afforded legal representation, including representation in those situations where their housing is threatened. Because a victim of abuse often lives with their abuser, often that abuser is on their lease, and often that abuser has compromised their housing by committing a criminal act on the rented premises. Perhaps they've drawn the attention of the police, perhaps causing disturbance to neighbors and other tenants in a building. Perhaps that abuser has damaged the property on the premises. Now, if that client resides in public housing or is perhaps on a Section 8 voucher or any other manner of federally subsidized housing, that client is afforded certain protections already under the Violence Against Women's Act. Protections that will ensure that victims of domestic violence are not twice victimized by losing their housing or a housing benefit simply because their abuser was on the same rental agreement. Federal law prohibits a landlord from using an act of abuse or threatened abuse that happens on rented premises as the basis for terminating a lease or rental subsidy. But such protections in their current form only exist to those in federal housing. LB 395 will bring Nebraska Landlord-Tenant Act closer to common sense protections afforded to the survivors of domestic violence in federally subsidized public housing. The bill provides greater assurance that victims of domestic violence need not fear reporting acts of violence to the police or obtaining a protection order such that courts will, to the courts and risk access to their housing. For these reasons, Legal Aid of Nebraska supports the passage of LB 395, and at this time I'm happy to take any questions.
Thank you for coming. Any questions? No, thank you. Welcome.
Thank you. Thank you. Thank you, Senators. My name is Alexis Steele. That is ALEXISSTEELE, and I'm the policy staff attorney for the Immigrant Legal Center, a nonprofit law firm that serves victims of crimes across Nebraska. I am testifying on behalf of our firm in support of LB 395. The Immigrant Legal Center supports this bill because it provides victims of domestic violence with a reasonable and much-deserved measure of housing security. Specifically, LB 395 would recognize that a victim of domestic violence is not in violation of the obligation to maintain his or her dwelling unit when that basis of that inadequate maintenance is the direct result of domestic violence. This obligation of maintenance rises under Nebraska's Landlord-Tenant Act, and it includes the obligation to not damage the premise and to maintain conduct on the premise that will not disturb neighbors' peace. These obligations are reasonable and desirable in themselves, but anyone familiar with the entrapments of domestic violence would recognize how impossible they might be for a victim to meet. Domestic violence is an assertion of power and control over a partner in an intimate relationship. This violence can be physical, emotional, sexual, reproductive, financial, and digital in abuse. Displays of physical abuse and emotional abuse can be particularly physically violent, and common displays of this conduct include physical assaults and destruction of property as means of intimidation. Such violence not only hurts victims, but also the physical home itself sometimes. It is important that our laws recognize that victims of domestic violence are, by virtue of their victimization, under the assertion of a perpetrator's control and power. The alternative is to render victims further helpless by not recognizing their suffering. LB 395 takes up the moral and expert call to protect victims of domestic violence. It is important to note that LB 395 does not eliminate any tenant obligations. It singularly recognizes that inadequate maintenance based on victimization is not grounds for termination of rental agreements. In practical terms, to a victim, this bill represents security in housing that an abusive partner would no longer be able to take away by violence. To a victim, it means being able to call the police without having to weigh the risk of indelible harm or death against housing. Nebraskans need this bill. In 2017 alone, Nebraskans made 4,427 reports of physical domestic violence assaults. That number does not even begin to capture the magnitude of the victimization because it represents the number of reports made, not number of victims harmed. Each report corresponds with violence that can, and often does, affect more than one person in the household, especially when children are present and inescapably embedded in the situation. The Immigrant Legal Center calls on each member of the committee to recognize the imperative to condemn domestic violence by advancing this vital protection for victims, so that they may one day become survivors. I welcome any questions and thank you for your consideration.
Any questions? Yes, Senator Brandt.
Thank you for testifying, Ms. Steele. You had 4,427 reports of physical violence last year, and maybe I should have asked this question on the previous testifier. How many of those resulted in loss of apartment or house?
So that information, as it's cited, comes from law enforcement reports, and those reports did not include that information. They did break down the number of simple aggravated assaults, or simple versus aggravated domestic violent assaults, and I have detailed the distinction within. I do wish that I could provide that information.
All right, thank you.
Thank you.
Thank you. Any other? No. Thank you very much for being here, Ms. Steele.
Thank you.
Next proponent.
Hello again. My name is still Dr. Erin Feichtinger, ErinFeichtinger. I still work for Together, hopefully, and we still have the same mission. We support LB 395 because it is one step in helping us to end homelessness. The connection between housing instability, homelessness, and domestic violence was well described by testifiers before me, so I won't repeat them. I just want to tell you that all of the people that we work with through our housing programs are homeless, and many of them are homeless as a result of domestic abuse. Many of them find it hard to escape homelessness because of domestic abuse. Recently, we had a client whose abuser, who was also on her lease agreement, we had worked with her to get her housed, made significant damage to her apartment unit while abusing her. We worked with her to move her out of state so that her abuser could not find her. She was not evicted, but she well could have been. We had to do a lot of negotiations with her landlord. She ended up being charged for the damage caused by her abuser on top of a new security deposit for a new apartment. Without our help, she would have been evicted. She would currently be homeless. Her abuser would still be able to find her. What happens to all the other victims of domestic abuse who don't have a small army of people working to help them find safety and stability? We believe it is fundamentally unfair and counterproductive to subject a victim of domestic abuse to eviction proceedings for criminal activity on the part of their abuser. All this does is perpetuate the cycle of poverty and trauma and negates the incredibly difficult work that has already been undertaken by a person to get themselves back on their feet. We understand that this is not the fault of the landlord either, and we know that many landlords are as concerned as we are for the safety of tenants. We understand also their concerns for protecting their property. Our concerns are for protecting our people. We want to thank Senator Matt Hansen for introducing this package of bills today, and we invite you to join us in our mission and in our work by supporting all of the important legislation that you'll hear today. And I'm available for any questions.
Thank you. Thank you, Dr. Feichtinger.
You got it this time.
Thank you. Only took me twice. So even though you are repeating or coming up here repeatedly, for the transcribers, we would still like you to say who you're representing, because otherwise we aren't going to expect the transcribers to go back and look for your previous testimony. So could you repeat who you're?
Yes, I represent Together Omaha, which has served the community for 44 years.
Great, thank you. We'll need to do that every time. Thanks.
Sounds good.
Questions? Nope, thank you. Any further proponents? Okay, what about opponents? And just to remind people, you can come down here. Thank you for doing that. Welcome.
Thank you, Senator Pansing Brooks and members of the committee. John Chatelain, appearing on behalf of Metro Omaha Property Owners Association. The name John, John, Chatelain, Chatelain. And I speak on behalf of our association in opposition to LB 395. It would amend Nebraska Revised Statute 761431, which provides for 30-day notice and also for a 5-day notice, which we sometimes refer to as the clear and present danger notice. Both the 30-day and the 5-day notice are very important tools for the landlord to be able to manage the property for the sake of the property and also for the sake of other people in the property if it's an apartment building. And I'm also a private practice attorney, and I do a lot of work in the landlord-tenant area, and I represent landlords, and we use the 30-day and the 5-day notice quite often. They are important tools, as I said. The proposal would be to subparagraph B of that statute, A tenant shall not be in breach or noncompliance under subdivision 1A of this section if the grounds for the breach or noncompliance is the direct result of a tenant being a victim of domestic assault under 28.323 or other crime committed against him or her by an intimate partner as defined in such section. Now, it's very unclear how this could be interpreted by the landlord. What would it mean to be that it was a direct result of a tenant being a victim of domestic assault or other crime by an intimate partner? And how would the landlord be in a position to determine whether one of the tenants was a victim of an assault? The victim and the other tenant would be in a position to know that, perhaps. They probably would be disagreeing about that, but certainly the landlord wasn't present, and the landlord would not be in a position to be able to make that determination. It's not clear how this could be administered or the mechanics of this could work. Now, without a finding and a judgment from a court, how would the landlord know if someone was a victim? This allegation would come up probably at the eviction hearing, that the person being evicted would claim that they were a victim of an assault of this nature, and the tenant would have the ability to provide evidence of what happened, but the landlord would not be in any position to be able to provide any evidence. And would this require some kind of court determination? It would take months for a case of this type to go through criminal court by the time the person was charged, arraigned, and tried. If it was a jury trial, it would take even longer. This would really frustrate the ability of the landlord to be able to evict tenants that were causing a disturbance in the property and causing a danger to the landlord or to other tenants in the building. Similarly, the 5-day notice would be frustrated by this bill because it would render the 5-day notice almost totally ineffective in this situation. It would be impossible for the landlord to refute an allegation that the tenant claimed to have been a victim of an assault in conducting the eviction process. So just because of the mechanics of this bill, our association opposes it. We certainly do not minimize, and we're certainly not insensitive to those people who are legitimately victims of assault. So that's all I have to say about it. If you have any questions, I'd certainly try to tackle them.
Senator Brandt.
Thank you, Chairwoman Pansing Brooks. I'm still trying to get an idea of the scope of this problem, and it sounds like your association represents a large number of units or landlords. How much of a problem is this? Does this represent where you have a domestic violence situation and they're at risk for losing their apartment or their house?
Well, most of the evictions come up because of a 3-day notice for non-payment of rent. But we do handle a fair amount of them that are based on a 30-day notice or a 5-day notice, the clear and present danger notice. Now, how often this issue would come up, we don't really know because LB 395 has not passed. I'm more concerned about the fraudulent complaints to get out of being evicted that would come up if LB 395 passed, and the inability of the landlord to be able to refute that claim at the time of the eviction hearing.
All right. Thank you.
Okay.
Thank you, Mr. Chatterlane. I'm more concerned about actual complaints that could come up. So it's my understanding that there could be an eviction for illegal use of a firearm or other weapon. Is that correct?
Are you talking about under the clear and present danger, the
Yes.
5-day notice? That is correct.
So how do you determine that? Couldn't that be continued litigation about whether or not it was, I mean, you can use the same kind of reasoning that you just used, that it could take a whole court order and determination whether or not it was an illegal use of a weapon or firearm.
Well, the landlord shouldn't file a 5-day notice unless the landlord has proof of that. And so it would be the landlord that would be the plaintiff in the case filing the case based on actual proof of those situations occurring. This allegation of assault between the tenant and the tenant's partner would be a different matter, because that information would be strictly between the two of them, and it might not even lead to a court case. So that the tenant could come into the eviction hearing claiming that he or she was a victim of an assault, which would make it very difficult for the landlord to proceed with the 1430-day or the 5-day.
So it couldn't be a use of a weapon between the two, some sort of illegal weapon between the two, the two tenants?
Well, it's unclear just how this would be interpreted when it says the direct result of a tenant being a victim of domestic assault.
Okay. Do you understand?
They could claim that that was a direct result of.
So do you understand the arguments made by the Nebraska Coalition to End Sexual and Domestic Violence that said this could have a chilling effect? It does have a chilling effect on people who are abused, and then they don't feel like they can even call police, because that action to call police could lead to their eviction.
Well, they have the option of filing a protection order, and that's probably what they should do in that situation. And a lot of protection orders do get filed.
And would that tie the hands of the landlords from evicting that person?
I don't believe so.
That's what's the concern.
No.
It's because, so would the landlord then be able to, if there was a protection order, can the landlord still kick a tenant out who?
I don't know why the landlord would. If the offending partner was the subject of a protection order and the victim was still in the rental unit and was not causing any further problems, I don't see why the landlord would evict in that situation.
I don't either, but we're hearing that does happen. So, but thank you so much.
Okay, thank you.
Next opponent. Welcome.
Thank you, Senator Pansing Brooks and the rest of the committee. My name is Lynn Fisher, Lynnn Fisher, and I represent my company, Great Place Properties, and also the Real Estate Owners and Managers Association here in Lincoln, which we're also members of the Statewide Property Owners Association. So, specifically on LB 395, as a landlord, our charge is, one of our responsibilities and duties is to provide safe and peaceful, quiet, comfortable places for people to live. Imagine you're one of my tenants and you live above another apartment, and the apartment below you has a couple of folks that aren't getting along, and one night at 2 a.m. you're awakened by lots of commotion and lots of activity, and police cars on the premises or neighbors coming out to find out what's going on with a lot of commotion. And you give me a call or send me a text and ask me, what I can do to take care of those kinds of things from happening again. And maybe they've happened several times in the past. So it's my duty to try and provide again for you the kind of peaceful enjoyment of your apartment that you would expect. So we need to have the tools in place for us to be able to make your place again peaceful and enjoyable. And I think LB 395 makes it difficult and sometimes maybe impossible for us to provide that for you. So we're opposed because we need to have all the tools we can to keep you as a neighbor from being an additional victim besides the people involved in that apartment below you. Any questions?
Okay, do you have any questions? Yes, Senator Sloan.
Thank you for coming out today, and I think you raised a fair point. Have you experienced situations like you illustrated in your testimony at your properties?
Yes.
How often do those happen?
Well, fortunately, not very often, because we are very, very careful to do a background check, and if anyone has this in their past, whether they're on either side of a domestic violence situation, if we find out through doing a rental history check that that's maybe a pattern in someone's life, we will not rent to them.
But it's still been something you've had to deal with as a
We still have had to deal with it, yes.
Thank you.
Any other questions?
Thank you.
Welcome.
Good afternoon, Senator Panzer Brooks, members of the Judiciary Committee. My name is Gene Eckel. That's G-E-N-E-E-C-K-E-L. And I'm a board member for the Nebraska Association of Commercial Property Owners and the Apartment Association of Nebraska, which is an affiliate of the National Apartment Association. I'm also an attorney that represents many landlords and apartment communities. I first want to say I intended to testify on all the package of bills by Senator Hansen. Unfortunately, I have to get back and pick up my son from school, so this will be my last testimony today. But I would invite Senator Hansen to work with us and contact me and see what we can work out on any of these pieces of legislation. We oppose LB 395 for a few reasons. Number one, it does prevent a landlord from protecting other tenants and management staff from violence associated with domestic violence. In 2015, the Nebraska Supreme Court held that a landlord owes a duty of care to its tenants. In that case, though, it involved where the landlord did find out that the woman's son did have a history of violence, and a few days later he assaulted an elderly man across the hall. It also makes it almost impossible for a landlord to remove a tenant if the perpetrator is allowed to come back to the rental dwelling. Under the 1430 provision, it's basically saying, look, if this happens, we're going to give you a warning. And it gives the tenant the opportunity to take steps to prevent it from happening in the future. We do support protecting victims of domestic violence, but we have to find that balance between a landlord's ability to protect the tenants and the landlord's ability to also do what they can to protect people who are victims of domestic violence. The 5-day notice provision, I drafted that. And when I drafted that legislation, I did put in those exemptions and my intent was to put exemptions in for victims of domestic violence. And as you see, it allows them to either seek a protective order or restraining order, or they contact law enforcement to initiate criminal action, which would probably relate to the domestic assault under Section 28-323. If they contact the police or other law enforcement, they're going to try to initiate some type of criminal action, which would fall under that and would allow the landlord to have that information that they have, that they are a victim of domestic violence. And I have to agree with what previous testifier did say. There is no way for a landlord to know if someone is a victim of domestic violence unless there is someone to support that. I can tell you that as an attorney, last year I did over 1,200 evictions. The times that I had to use an eviction for a 5-day, none of them involved domestic violence. Typically, it's going to be where someone has assaulted someone on the property. Maybe it might be someone who's a guest or another person, but it wasn't an issue of domestic violence between partners. Or times it would be some other criminal act. With regard to the 1430, typically that's going to come up where it continues to happen over and over again. A lot of my clients, they want to do something to help out the victim. And they want, some of their questions are, is there some way we can work with this tenant so maybe their husband or boyfriend who's on the lease, can we just have that person evicted and allow this person to stay? So at least my clients try to do what they can to help the victim. But when it gets to the point where it's consistently happening over and over again, and they have other tenants who are in fear of the violence that's going on, and they say, I want out of my lease, the property manager and landlord have to do something at that point because they have that duty of care. The only thing I would ask is that...
Can you just quickly wrap up?
Sure.
The lights on?
Here's one. I want to just add that if there could be in that exemption provision on the 5-day notice, that perhaps it would just limit it to the tenant can only use that exemption once during the lease term. Because again, it can continue to happen over and over again, and that puts the landlord and other tenants in a very dire situation. With that, in my testimony, I would just ask the committee to oppose LB 395. I'd be happy to answer any questions.
Any questions? No, thank you.
Thank you, Senator.
Next opponent. Please come down if you want to testify. Welcome.
Thank you, Senator Brooks, members of the Judiciary Committee. Again, my name is Samuel Lyon, Samuel-Lyon. I want to thank you for taking up matters of rental things. I think a lot of times we just sort of get forgotten as landlords and tenants, and I think as you'll see today, there are a lot of nuance. There's a lot of nuance to leasing a home to an individual for a term of time. And as landlords, we do that gratefully and happily and just dutifully, I guess. I mentioned that I've had rentals for 15 years. The first rental that I bought was a duplex, and then I bought 2 more duplexes. I think that multifamily housing is substantially different from single family as it comes to these types of issues where you might have disturbances to an individual that has nothing to do with the party that's in that. They're in a duplex or side by side and they're hearing noise at 2 a.m. I have had those 2 a.m. phone calls several times, and there is no worse feeling as a landlord than somebody calling you, waking you up at 2 in the morning saying they're screaming over there and I don't know what to do. What can you do? I want to be clear that as far as domestic violence goes, there's nothing worse in my book than a man, and generally it is men, that try to dominate and intimidate and abuse generally women. And as a landlord, I'll do anything that I can to help out a woman stuck in that situation where there's a man that's trying to intimidate them and dominate them. And I've worked with several. In both cases, neither of the men were on the lease. They were boyfriends that came. They generally provided some level of financial support, and that's why the woman kept allowing them in. I want to thank the previous testifiers for their help in these situations, because this is a huge problem in our state. But I would agree also with the previous testifier that says there's got to be some kind of something as far as a limit to how many times that they could use this to not be evicted. I've never evicted anyone for this reason. It's always been rent, and generally speaking, in these cases, there's also destruction of property and late on rent and a lot of other things that we could use. But as landlords, we don't want to kick people out. We only get paid when people are living in the place. But we also don't want the neighbors leaving because they're tired of the doors getting smashed in next door and windows being broken out. So I just urge you to think about it from both sides and think, how can we come to a conclusion that's good for everyone? And in most cases in both cases that I saw personally, it's up to the woman to assert herself, and if they won't assert themselves, there's not much that anyone else can do. So I appreciate that people are helping women assert themselves against people that would abuse them. And
Thank you, Mr. Lyon. Any questions for Mr. Lyon? Nope, thank you very much. Next opponent. Welcome.
Again, my name is Scott Hoffman, Scotthoffman. And actually, to address Senator Slama's question about whether I've experienced it, and yes, I have. This happened about a year ago. I'll just refer to his name as Michael. And I have a tool from the Lincoln Police Department that we are on their email alerts. If a police officer shows up at one of our properties, we actually get alerted, no matter whether it's domestic or assault or drugs, if a police officer shows up at the door, it's a nice tool that we have. So there is a way to find out if it's domestic, and it was. We have it in our lease just simply as assault. We don't refer to it as domestic or whatever. But that is a 14-30-day call for me. And in this case, it happened, right around the end of July. Normally, we do not give a 14-30 unless it's delivered on the first of the month. And to correct Senator Hansen's interpretation of the 1430, and this comes from my attorney. The 1430 is delivered, you give it on the first, you collect your rent for that month, and if they don't do anything, which he did, he assaulted her again, and I said, okay, that's it, because we just don't want to be involved with it. Both parties need to leave, and so we wanted to terminate the lease. But within that 14 days, if they do not commit a violation, then everything goes back to square one and everything's okay. Now, if it does happen, then they have to be out within 16 days. There's no eviction. There's a difference between termination of lease and eviction. There's two different causes here. So if they're not out by the first of the following month, then I have to go to my attorney and say, okay, we want to terminate the lease. They didn't move out. And so that's another 14 days for a trial. So there's almost 45 days that goes by. So I guess senators were asking, how long do we sit around until they figure this out, and how long is the perpetrator going to live there with the victim? So that's the purpose of how to diffuse it. But the bottom line is then they can get another week to vacate. So it could almost go on for 6 weeks. So there's a difference between eviction. Everybody's going eviction. You have to go to court, and it takes 14 days for a trial while people sit about it and think about it. And in the meantime, we can't do anything. And we did do a 24-hour notice to inspect the property. He was kicking in doors, busting holes in walls, all the stuff we had to repair after and they did vacate. They did decide to vacate at the first. So we didn't have to go to trial. There was no eviction. It's just a terminated lease, and they agreed to leave. So I entertain any questions.
Any questions?
All right, thank you.
Thank you very much for coming. Next, opponent. Okay, anybody in the neutral? Okay, Senator Hansen to close.
Thank you, members of Judiciary Committee. So relating to this issue, I kind of want to talk about the process issue of how would the court figure this out, or how would the landlord know? The landlord has to know something has happened in order to give the notice and ultimately get to a court case. They have to have some idea in their mind, to even instigate this whole process. So having the burden of asking them to, or not even necessarily asking them, having the defense for the person, or for the tenant, seems like a logical step. We just know an assault happened. How are we ever going to figure out what type of assault it is? It's like, we still have to know an assault happened. You still have to know something happened in order to start this whole process. In terms of it being messy or confusing or taking a long time, this is an affirmative defense the tenants can raise. You're in front of the court. You're at threat of being eviction. We've gone through all of the notice requirements. And you say, hey, the underlying cause here is, my ex-spouse was dropping off the kids pursuant to our custody order, so therefore they were a guest, and in the process, we got into a fight, and he shoved me, he punched me. And that's a finding the court can have. I also think it's kind of a little interesting that we trust courts to go through the same courts to go through all the criminal cases. We trust all the courts to go through the protection order orderings, but then all of a sudden we have the same standard. We're asking the same judge to apply in an eviction proceeding. We're all of a sudden worried the judge can't figure it out. It's a standard they apply in both protection orders and other instances. And I just kind of, going back to the fundamental principle, I don't know if evicting the victim of a domestic violence is a benefit to the victim of domestic violence, and that was kind of the way it was framed a little bit. Fundamentally, this is just kind of a last result of I'm about to be homeless, I'm about to be kicked out because I'm the victim of a crime, and you get one last chance in front of a judge before before they issue the eviction to say, hey, the whole purpose of this was I'm the victim of a crime. With that, as always, I'd be happy to work with all stakeholders and thank the committee for their time.
Thank you, Senator Hansen. That closes the hearing on LB 390. Oh, do you have a question?
Yeah, just a quick clarification question on my end. How are we supposed to determine
if the tenant in question is a victim of domestic assault, if under our current criminal courts we have a presumption of innocence until proven guilty. So until they've gone through that process, we can't make a definitive determination as to whether or not a crime occurred because we're presuming the innocence of the other party.
That is, I guess, that's an interesting way of framing it, and I hadn't considered it that way. My intent was to not delay this to the point where you had to wait for the criminal trial to go forward, because as we'll see in some of these other bills, these hearings are very expedited. Maybe we could potentially double check and change the wording that alleged to be a victim or something, or have some sort of evidence standard that they would have to bring to clarify that it's separate from the criminal case.
Thank you.
Of course.
Thank you, Senator. We have 4 letters of support of LB 395 and 1 letter of opposition and 0 neutral letters. So that closes the hearing on LB 395. Senator Hansen is here again for LB 396. Senator Hansen.
All right. Good afternoon, Vice Chair Pansing Brooks and members of the Judiciary Committee. My name is Matt Hansen, M-A-T-T-H-A-N-S-E-N, and I represent District 26 in Northeast Lincoln. LB 396 outright repeals Section 76-1443, which prohibits judges from granting continuances in eviction proceedings unless extraordinary cause is shown and a cure to back rent is paid. In my work this past interim, working with the Nebraska College of Law Civil Clinic, I was surprised when they informed me that Nebraska is the only state in the country whose Residential Landlord-Tenant Act effectively prohibits continuances in eviction proceedings by only allowing them when, quote, extraordinary cause is shown, rather than the good cause standard used in every other civil proceeding. I know there's some attorneys in this room, but for everyone else, a continuance is the postponement of a legal proceeding granted by the judge at the request of either party or the judge themselves. Not only is Nebraska unique in this aspect, but within Nebraska, eviction proceedings are unique in that they're the only type of proceeding with this extraordinary cause standard. LB 396 would, of course, not mandate continuances, but would allow the judge discretion to decide if a continuance is warranted in limited circumstances. It is not right for something that has the ability to evict someone from their home. The court has such little authority to reschedule a hearing, especially when it is commonly granted in all other civil matters. We've heard attorneys who've had clients evicted for simply not being able to take off work at the specific date and time of the hearing. We want to make sure they're not creating a system where people are deprived their day in court and being evicted from their homes because they're unable to be present at a hearing. Behind me, there are testifiers who work directly with clients affected by the statute who will be able to give more details. But with that, I'll close and be happy to take any questions.
Any questions for Senator Hansen? Nope, thank you.
Thank you.
First proponent, and how many people do we have testifying in this bill? Thank you. First proponent, and if you could come down here and fill in the seats, that would help us move this at a more rapid pace. Thank you. Welcome.
I have some handouts. Good afternoon, Chairwoman Pansing Brooks and members of the committee. My name is Sam Rabine, S-A-M-R-A-Y-B-I-N-E. I'm a senior certified law student at the University of Nebraska College of Law, and I co-lead the Civil Clinical Law Program's Tenants' Rights Project. I am testifying in support of LB 396 as a citizen, not on behalf of the university. I will address the 2 provisions in 76-1443 that disproportionately burden tenants, the cause to be shown, and the payment of past and future rent, and I will explain why this law needs to be repealed. This law requires that tenants show extraordinary cause in order to qualify for a continuance in an eviction proceeding. As Senator Hansen just informed you, Nebraska is the only state in the country whose Residential Landlord-Tenant Act contains such a provision, and it is not included in the Uniform Act. This provision is not only inconsistent with other states in the Uniform Act, it is inconsistent with Nebraska law. As described in detail in a document I handed out, in all other matters, a continuance will be granted for good cause shown. To highlight this discrepancy, in eviction proceedings involving commercial tenants, a court is permitted to grant a continuance for good cause shown. But in a residential eviction, where the result is possible homelessness, the tenant is required to show extraordinary cause. Common good reasons for requesting continuance, such as work conflicts or transportation concerns, will likely not meet the standard of extraordinary cause. Even the inability to consult with a lawyer will likely not constitute extraordinary cause, which is an outrageous conclusion to reach. Second, not only must a residential tenant show extraordinary cause, they must also pay all rent the landlord claims is due and will accrue during the case. This provision is grossly unfair because tenants are essentially having to pay for the opportunity to fairly and reasonably present the merits of their case, a request that would be granted in all other legal proceedings upon a showing of good cause. We are aware of the time-sensitive nature of eviction proceedings, but the way that Nebraska's continuance provision is currently written effectively precludes tenants from being able to receive a continuance to present their defense to the eviction. Nebraska law is making tenants homeless because they don't have enough time to consult with an attorney, prepare a defense, or because they can't take off time from work on the day for which the landlord scheduled the hearing. Considering what is at stake, 76-1443 needs to be repealed. There's no reason to amend it, as there are other laws in the books that already govern continuances upon a showing of good cause. By repealing this law, judges will be able to use their discretion to determine whether there is good cause to continue the hearing in order to preserve a fair and just proceeding and due process under the law. At this time, I would be happy to take any questions that you might have.
Any questions? No, see none. Thank you for coming. We're always pleased to see law students.
Pleasure to be here. Thank you.
Next proponent. Welcome.
Thank you. Good afternoon, members of the committee. My name is Joy Katharima, Joykathurima. I was a senior certified law student at the University of Nebraska College of Law in the fall of 2018 and was a co-leader of the Civil Clinic Law Program's Tenants' Rights Project last semester. I'm testifying in support of LB 396 as a citizen and not on behalf of the university. I want to express to the committee how harmful 76-1443 is to low-income tenants and why repeal is not only necessary, it is urgent. I will do so by sharing a story of a hypothetical tenant who has suffered as a result of this law. The facts resemble many cases the clinic has handled over the years. Imagine yourself as a young single mother working 2 jobs to make ends meet. To make your life harder, the water heater breaks down in the duplex apartment you rent. You properly give notice to your landlord and he assures you that he will take care of it. Yet he never does. Finally, after going weeks without hot water, you are forced to purchase a new water heater with what little money you have. When the first of the month arrives, you are unable to afford rent. It was spent on the hot water heater. Immediately, you are notified by your landlord that he has terminated your lease agreement and that an eviction hearing has been scheduled in a week. You think you have a defense because of the hot water issue and because the landlord did not properly serve notice, so you plan to ask the judge for some time to contact an attorney to represent you. You take the morning off from work to go to the hearing, you explain your situation to the judge and ask for a continuance to seek legal counsel. The judge is sympathetic to your situation, but however, because of this law, your hands are tied unless you can come up with the rent plus future rent, which you cannot. The judge has no choice but to deny your request. Having no evidence to present, the judge finds in favor of the landlord. Soon after, the sheriff arrives at your home, moves all of your and your children's belongings to the curb, and locks you out of your home. You are homeless. You are homeless because of this ridiculous law that was written by landlords 40 years ago. And because 40 years ago, tenants had nobody there to fight for them. But we are here now. We are here to support the repeal of a law that should never have been adopted. This law prevents tenants from having a reasonable opportunity to present their case. There's no other state in the country that has an anti-continuance statute like this. This law is cruel and draconian. Nobody should lack access to legal process because they can't satisfy an arbitrarily enhanced burden or because they lack the funds to buy their right to present their defense. That is why I'm testifying in support of LB 396, and that is why 76-1443 should be repealed. Thank you.
Any questions? Well, I have a question. Thank you for coming. I was wondering, do you know, can you talk about judicial discretion under this bill a little bit? Is there judicial discretion?
Yeah, so when, in any continuing situation, there would be judicial discretion. So if this if this law were to be repealed, there would still be judicial discretion. It would just be under a good cause standard instead of the extraordinary cause standard demanded under the current law.
Okay, but as you stated in your hypothetical.
Yes.
They really don't have judicial discretion.
Yeah,
the law is stated now.
Yeah, with the law stated now, the extraordinary cause burden makes it hard for judicial discretion to really be applied because extraordinary cause is such a heavy burden for the tenant to be able to show. So even if the judge was like, I'm sympathetic to you, you haven't shown what is considered extraordinary cause, their hands would be tied to not be able to actually help the tenant have their day in court.
Okay. Let's see. I think that's all I have. Thank you, Ms. Cathermura. Thank you for coming today. Again, we're happy to have students here.
Thank you.
Next proponent. Welcome.
Thank you. Thank you, Senator, members of the committee. My name is Scott Mertz, S-C-O-T-T-M-E-R-T-Z, and I'm a managing attorney with Legal Aid of Nebraska, an organization that is the sole statewide provider of free civil legal services, in Nebraska. So for over 9 years, as part of my job, I've advised or represented hundreds of low-income tenants faced with eviction. These individuals come to us confused, they're upset, and they do not understand their rights, and they do not understand their responsibilities under landlord-tenant law. One thing these tenants do not fully understand is the speed with which they can be removed from their home through judicial eviction. Most do not appreciate that after delivery of a written notice that gives a tenant no more than 3 days to come up with the rent money or have their family fully removed from their premises, a summons can soon follow that assigns a court date with as little as 10 days notice and no more than 14 days notice. These individuals will then have to appear in court and try their case under the rules of evidence, and after which a judge will render a final judgment and possibly have that family removed from their home on the very same day. And within this very short process, Statute 76-1433 prevents such individuals from obtaining a continuance in order to attend and adequately prepare for a trial that will determine if they can remain in their home or be forcibly removed by law enforcement. Our clients are low income, but they most often still have jobs. They have children without adequate child care. They are living paycheck to paycheck. It is near impossible to adequately prepare for such an important hearing under such short notice. These individuals are mostly unrepresented, as there are few to zero options for representation in such cases outside of our own organization and potentially the civil clinics administered by the law schools. The landlords, however, are almost uniformly represented by counsel when in court. So in my 9 years of practice, primarily in Douglas County Court, I have witnessed thousands of pro se clients appear before a county court judge, often by the dozens in a typical day, appearing in rapid succession, all faced with the eviction from their home. Most are ill-prepared to proceed with their case. I've witnessed their failed attempts to get just a little more time before proceeding with the trial, time to obtain representation, or even just consult with an attorney before the case can proceed. I have seen these individuals appear without necessary witnesses, without necessary evidence. A continuance would afford such individuals some manner of dignity, some semblance of fairness under this process, but the existence of 1433 prevents the judiciary from exercising the discretion to grant a continuance for anything but the most extraordinary cause. This requirement unfairly treats tenants facing eviction as a special class of defendant unworthy of the exact same rules afforded to every other party in a civil matter in the state of Nebraska. The passage of Bill 396 would restore some semblance of fairness to the eviction process, and Legal Aid in Nebraska supports the passage of Bill 396. And with that, I'm open to any questions.
Thank you, Mr. Mertz. Any questions? Nope. Thank you very much for coming today. Any more proponents? Okay, opponents. Opponents. Welcome.
Welcome. John Chatelain, John, Chatelain, Chatelain. And I'm speaking on behalf of the Metro Omaha Property Owners Association and the Statewide Property Owners Association today in opposition to LB 396. And LB 396 would repeal Nebraska Revised Statute 76-1443, which is part of the Nebraska Residential Landlord Tenant Act. And it provides for no continuance unless there is extraordinary cause, and then not unless the defendant shall deposit with the clerk of the court payment of the rents that have accrued. And typically, the way an eviction case works is that the landlord will try to work with the tenant. If the rent is due on the 1st, the landlord will try to work with the tenant if they're a little bit late, because the landlord doesn't want to have an eviction, doesn't want to have an empty house, and doesn't want to evict the person. So possibly the 3-day notice might be served around the 8th or 10th of the month, and then 3 days have to expire. Typically, the complaint is not filed immediately at the expiration of the 3 days. Again, the landlord is wanting to work with the tenant. And then the hearing will come up about 2 weeks later. So now we've got probably 3 weeks or 4 weeks into this process without the landlord receiving any rent. And then the eviction hearing, if it is successful for the landlord, then the final stage is the filing of a precipice for a writ of restitution, and then the writ is served by the constable or the sheriff, which takes about another week. And so the landlord's probably going to have about a month or 6 weeks invested in this process without any rent being paid. Now, there was testimony about having to pay the rent for a continuance as an imposition. I don't see that as an imposition because the tenant agreed to pay the rent in the first place and is not doing it. And it's unfair to the landlord to have them go on for continuance maybe more than once without receiving any rent. If LB 396 were to pass, I would foresee that the cost of providing for the possibility of being denied rent for longer periods of time would need to be factored in. This would likely cause stricter screening procedures, possibly denying some people the ability to rent a property. Another likely result might be higher rents for the tenants, because this extra benefit to the tenant would have to be funded. Landlords operate on tight budgets. You've probably noticed real estate taxes are going up all the time. Landlords have to pay principal, interest, taxes, insurance, maintenance, and these items don't stand still.
Thank you, Mr. Chatelain. If you could just finish.
Yes. These items don't stand still while the tenant is not paying the rent. So it is a serious matter to the landlord that the rent be paid.
Thank you.
Any questions?
Any questions for Mr. Chatelain?
Thank you.
Next opponent.
My name is Scott Hoffman, SCOTTHOFFMAN. I guess the question, Senators, I have is how much time are we supposed to give them? It's ironic because I actually wanted to come in, and we may do this next year. We wanted to move up the court date. We want to go 7 to 10 days because the 14 days there's 2 weeks right there. And then we got to wait another week for the constable to come along. And not only that, within the 14 days, we're advised by our attorney not to harass them or come over and talk, which we certainly don't. But there's other expenses involved. We've got utilities. We have like a landlord revert with Black Hills Gas. These people will not pay the gas bill. It goes back into our name. In fact, that happened the last eviction that I had. We also have, if they're living in a house and not paying the water bill, it's assessed to the property owner. So they're using, basically taking a hot shower on us. Pardon the pun, but that's what I always refer to it as. So there's other expenses involved than just paying the rent. I fortunately own some of my houses free and clear, but I sympathize with the landlords who have a mortgage payment to pay on top of the interest and the taxes that we're dealing with. So the point is continuing for how long? You had 2 weeks to decide what you want to do. Now, most of the time, these people will move out the day before the trial. I'm serious. You go to court, I invite any of you senators, seriously, go down to Lancaster County Court, the eviction court, and just sit there as an observer. Just go to court and see what's going on down there. It's going to be mostly the landlords, and then the tenants come up, and they show up like they're supposed to, and they're not paying the rent, and, they ask, it's ruled in favor, and it's the writ of restitution, you get the property back. But the problem is, 2 weeks have already gone by, and to actually sit there and wait for them to get counsel when they can't even afford to pay the rent is another issue. I don't know how many, everybody knows what an attorney charges. Some of you are attorneys. I don't know what your hourly rate is, but you're dealing with that too. So other than that, any questions? I'm done here.
Any questions? Senator DeBoer.
What would you say is the percentage of non-payment of rent you have, that goes to eviction of the tenants that you have? What percentage of your tenants do you end up in these kind of proceedings?
Well, I mentioned that earlier, Senator DeBoer. In 35 years, I've had hundreds of tenants. I've got 17 parties that I deal with, and I've only done 5 evictions, and they were ugly. I mean, these people, they're basically career deadbeats. They know the law. You see some of the same people down there again and again and again. An unwearing landlord rents to these people. I mean, we do want to get our rent, and not to mention partial rent, too. I mean, no rent at all. If you rent $700, why don't you throw me a bone, give me $300. I'll work with you on the other $400. We always do that. But to have nothing at all for a week to 3 days is an issue.
So that's a pretty small percentage.
Very small percentage for me, but it's always a non-payment of rent. It's not a 1430. It's usually the people can't pay the rent, and they've been there for 2 weeks, and the trials, they've had plenty of time.
I ask you this because I used to sell apartments for a long time, and
sure.
So I was in the office and I saw that it was a very small number of these, that it was. So I think in the amount of, total amount of money that you're getting in rent each month, you're missing out on not a huge portion of your income each month. It's a small portion that you would be missing from these non-payment of rents.
Well, it's the utilities that go back into our name too. But a lot of times, Senator, these people do not show up for court. They'll stay there for the whole 14 weeks and what we refer to as milk it, and you won't see them in court. I mean, half the time the defendant's not there. And we routinely go over there the day before the trial to see if they're there. We don't go knocking on the door, but if we see evidence that they may be there, we...
So I guess I'm confused.
Yeah, go ahead.
So you routinely, but there were 5 times over the course of your rental, so...
Very low.
I'm missing this. Routinely in the 5 times, or routinely there's some other process that you're talking about that I'm not?
I'm saying when I've gone down to eviction court, this is what I've witnessed. As far as when I have gone down. I've been down there other times when I wasn't evicted. Otherwise, not that just the 5 times, but more than 5 times, talking to other colleagues or landlords, dealing with evictions. So,
okay. Thank you.
Yeah, thank you.
Yes, thank you. Senator Moorfield, go ahead.
Thanks for coming today. I guess, so I understand that there's some deadbeat renters. I can understand that.
Certainly.
My parents owned a rental property. I helped them manage it. As a teenager, I saw what happened. I own a rental property right now. So I understand that there's deadbeat renters, but the problem is that there's also deadbeat owners. And I've experienced those people too. I've represented some of those people in terms of getting them to resources that they needed. And so it's a balance of due process. So what if somebody has a valid claim? Shouldn't they be afforded the same due process as anybody else with the valid?
Are you, Senator Murphy, are you talking about a 1430 where the landlord's not living up to his repair obligations? Or
That might be the case, and they may be confused as to what their actual legal options are. What I'm saying is, what if the tenant has a valid legal defense to, you know, the eviction action. So shouldn't they have the same ability to have a continuance and it not be extraordinary circumstances?
If it's in, Senator, I guess if it's involved with not paying the rent, you got 2 weeks, you know, and we have bills to pay. I mean, you know, mortgages, yeah.
I get that you have bills to pay. I have bills to pay.
Certainly, certainly.
I have a rental property.
Actually, it was one of my questions to see if any of you senators actually own rental property and you deal with it.
Absolutely.
Yeah.
I've seen good renters, I've seen bad renters, but I see a lot of bad people that actually rent out property too. I think there's more good ones than bad ones, but the problem that I have with this is it seems as compared to other legal actions and due process, it doesn't provide the court, it doesn't provide the individual the same ability to have a continuance as any other legal action, which bothers me. But I see your perspective, but I think that we have to acknowledge that there are also deadbeat homeowners too, and other folks that, you know, that we need to make sure that renters have protections.
Well, that was one thing I was answering to, you know, as far as paying the rent, because when my tenants do come in and we also say, well, can you come up with a few $100s, and they usually do, but to have none of the rent and wait for 2 weeks for a trial and then have more continuances, I don't see that.
How many times have you had a continuance? How many times has somebody asked for a continuance?
You mean to pay the rent and partial rent, or?
No, what we're talking about here, in the court action.
Well, there is no continuance. That's what they were trying to pass the bill for.
Yeah, I mean, that's the thing, is they can't do it because it's extraordinary circumstance.
But I have stayed out of the courtroom, and I've only done 5 evictions in 35 years because I've dealt with tenants that have paid me partial rent, and I've dealt with that probably 40 or 50 times. I had one guy, literally after a year and a half, I said, Dante, you're going to go, because every month he would do this. He would pay the rent late. So.
No, and I totally sympathize with the fact that you get some deadbeat renters, and I've seen that happen before, so I'm not dismissing that. I'm just, it's a balance and it's a fairness issue, and I know that there's another side to that.
It comes down to the application process too.
So. And I appreciate you coming in today, sir.
Thank you.
Any other questions? No, thank you. Additional opponents?
Gareth Rees, Garethrees. I'm here in opposition to this. The law requires, if you are going to collect rent, you must give personal service on the tenant. If your only goal is to end the tenancy of the tenant, you can use post and mail. So rent is not delinquent for me until the 3rd day of the month. If on the 4th day of the month I give notice, 3 days, it takes me to the 6th. I then have to go to my attorney. He has to file the proper paperwork, and now we've got 14 days, and occasionally the judge does not adhere to the 14-day rule, but it will be somewhat later. So we're getting to the 20th, 21st day of the month, and you've collected no rent for that month. I have no hopes and no goal of collecting rent from the people on whom I'm engaged in an eviction. My sole goal is in a vacant apartment so that I can rent to somebody who does pay rent. So the entire purpose of this legislation, as far as it affects me, is providing additional free rent to a tenant who is not going to pay rent. I have never collected rent from somebody that I evicted. It simply doesn't happen. So the purpose of this legislation is to require me to provide additional free rent to people that I rented to. Do you have any questions, please?
I have one. Thank you for coming, Mr. Rees. So what happens if somebody's in the hospital and can't make it to the hearing, and the judge has his or her hands bound by the exact date of, like, well, you didn't pay, you're in the hospital, too bad. The law says no discretion, you're out. Do you feel that's fair?
I've never had that circumstance.
Okay,
it would not be fair that somebody is in the hospital and they get evicted, but I've never had that happen. My problem is always someone who makes the choice to get a free month's rent and to just continue.
Okay, thank you very much, Mr. Rees.
Thank you.
More opponents. Welcome.
Hello again. My name is Don Pearston, D-O-N-P-E-A-R-S-T-O-N. A quick story about myself. I moved here about 19 years ago from Southern California as a student, and I bought an old rental, a little over 100 years old, and continued to work. And for 18 years, I've built my rental business as really a gritty blue-collar worker. And I wanted to tell you that I do my own legal work because from the beginning, I was working 2 jobs in the daytime, and I couldn't afford $300 or $400 for an eviction attorney. So I got the proper documentation and learned how to go to courts. And since all my buildings are older, the tenants that I rent to are on the lower socioeconomic scale. It works for me, and I've been successful of helping tenants and building strong relationships over these 18 years or so. But in doing the legal work myself, I've sat in Judge Rodney Reuter's court quite a bit. It's unfortunate that he knows my name. I sit in the back, and once all the lawyers and attorneys have cleared out, he calls me up, "Don, come on up." And so this bill looks to me like it'll mandate a continuance, but I see continuances happening in the courts all the time. I've sat in those courts hours. My question to you as senators, have you sat into an eviction court at all? 90% or more evictions are over non-payment of rent. It's not the 14-day notice, damage, or other issues. It's non-payment of rent. And sometimes the lawyers will get together with the tenant, and a continuance will be given, just not mandated, of course. One of the persons given testimony earlier mentioned that the example about the water heater. There are laws in place where tenants can let their landlords know that things need to be repaired already. And so, having some, like the gentleman before me, is just another gouging of landlord. Of course, some landlords don't take care of their properties and so forth, but my contention is that offering up a continuance when a tenant already knows they've got, I give a 3-day grace period, and then on the 4th day I'll give a 3-day notice. On the 4th I go file my case. From that date I got 14 days until the court date happens. And I'm here to talk about 434 more specifically about that. But how many weeks, my question to you is, how many weeks should a landlord give a tenant to get prepared? That seems to be the case for the other side. I would hope that 3 weeks is more than plenty for a tenant to get legal representation.
Thank you, Mr. Pearson. Any questions for Mr. Pearson? No, thank you for coming.
Thank you.
Yes, if everybody could please remember to watch the light, because we really are trying to keep it so that everyone gets the same amount of time. Thank you very much. Welcome.
Senator Pansing Brooks, Lynn Fisher again, Great Place Properties. My name is spelled Lynnfisher. And I'll try to be very brief just to cover a couple of points that have been brought up. The example of the water heater going out and the landlord not taking care of it, the tenants have lots of rights. They can give a 3-day notice to the landlord for not taking care of a problem like that. They can call Building and Safety. Building and Safety will be out there the next day. It'll get taken care of, believe me. And if a tenant has the money to pay for a hundreds of dollars repair for a water heater, they're better off to pay the rent, call Building and Safety, get it taken care of. To address what judges will or will not allow their discretion, Senator Pansing Brooks, when you're in eviction court, judges exercise discretion all day long. The law may be a particular prescribed procedure, but they vary from that often in order to accommodate what's reasonable for both landlords and tenants. Attorneys for landlords will negotiate out in the hallway lots of different agreements to try and accommodate what's reasonable in each circumstance. So just because the law says that a continuance may not be granted. If somebody's in the hospital, if a tenant comes in and says, hey, my landlord didn't replace my water heater, and that's a situation, a judge is not going to say, sorry, we're going to evict you, even though they know that there's some extenuating circumstance. So that just doesn't happen. So that's not really a realistic example. As you know, from past testimony, if you maybe recall, that I've been involved with RentWise, which is a program for folks that are trying to do better at being a tenant. Most of them are on the low income scale. And over 10,000 people have taken advantage of RentWise just in Lincoln alone. And those people are made fully aware of all the resources available to them, including the services of legal aid. And so we let them know that they have lots of different ways that they can go about getting help for particularly dealing with the bad landlords out there. And there are, Senator Moorfield, we agree, but thankfully it's a very small minority. We have to answer any questions.
Thank you. Any questions for Mr. Fisher? Mr. Fisher, I think part of the problem is that it may be working well in Lancaster County, but there could be other counties across the state with which you might not be familiar that we're getting anecdotal evidence and letters to the fact that there are cases where the judge just says, you missed the date, that's it, you're out. So
most of my judges that I've dealt with here, for sure.
I think we have good judges.
And in York County have done a good job.
Thank you very much. Any more opponents? Welcome.
Thank you. Larry Storer, S-T-O-R-E-R, 5015 Lafayette Avenue, Omaha, Nebraska. I know you folks are getting tired of me, but 2013 Constitution of the State of Nebraska. Article 1, Section 25, the rights of property. It also gets into no discrimination in aliens, but there shall be no, et cetera, et cetera, et cetera. In respect to the acquisition, ownership, possession, enjoyment, or descent of property. Well, a rental property is the rental property of a landlord. It's not the property of a tenant. And the landlord has superior rights under the law, general law. But we have a constitution now that instead of being a pocket constitution that is 3,000 pages long, due to judicial interpretation and progressive rewriting of the laws and rules and regulations that supposedly back up those laws, because the courts delegated and Congress delegated their responsibility under the Constitution. That applies to Nebraska also. I don't think I want to be a landlord. I need to supplement my retirement income, again, to help pay my property taxes, because the inspectors might come and take my property any day, and I need to fix it up. I see we're rewriting the inspection laws as I speak. I'm not prepared for that. Are the tenants prepared for that? I think the time frames in this bill are extremely difficult for anybody that's considering to be a landlord, or even staying as a landlord, remaining as a landlord. There's other laws that cover this, I think. Yeah, if somebody commits a murder, that should be out of my hands. If I'm the landlord and somebody commits a murder on my property in one of my tenants' apartments, whether they're a same-sex spouse or not, other laws control that. That shouldn't be in here. There used to be a publication called Common Sense that aroused the citizens' blood pressure. And they went and decided they were going to rewrite their Articles of Confederation after they finally met and had a confederation. They had a small constitution, but they decided it wasn't good enough. They didn't trust their legislators because a lot of them were loyalists. We did not have the Constitution yet. So I don't know why they think we should trust a unicameral where the people do not have a voice. Thank you.
Thank you, Mr. Storr. Any questions? Okay, any further proponents? Any neutral testimony? Senator, oh, neutral, okay. Welcome.
Thank you, Senator Brooks. Again, Samuel Lyon, Samuel Lyon. I wanted to just give a neutral thought, a couple of thoughts here very quickly. As I have a washer that I need to go pick up and take to one of my tenants so they don't pay for it and take it out of my rent. Thank you for your consideration of these bills. As you can see, there is a lot of nuance. Thank you for putting up with us, landlords. We are quite the cast of characters, as you can see. I realize like most of this legislature is not for me. It doesn't affect directly my day-to-day because I'm a good landlord. Specifically this one, I can come down as neutral because I haven't actually been through a eviction process totally yet in 15 years. So if I go next year to an eviction process and if they get a couple continuances, that's just the cost of doing business as far as I'm concerned. But one thought that I will leave you with as you consider this legislation is I don't generally give notice until 30 days past rent. So I try to work with the people and say, hey, what's going on? Did you lose your job? Do you have a kid that was in the hospital? What's going on? How can I help you pay the rent? The tighter the legislature gets on me, the quicker I will be to give that notice, right? Because I know now I can give the notice and then kind of get through it. And so I can wait and talk to them and try to communicate and get that rent going. But if I know, hey, you've got to do this, and then there's another continuance and maybe another continuance, then maybe on the third, I'm just serving them notice. Again, I'm not kicking them out, but I'm starting that process much sooner because I know that the process is longer. So just as you consider this legislation, know that might be an unintended consequence. Not that it's retaliatory, but I just know if this is a 3-month process, the sooner we can get going on it, the better off we'll all be. So that's my thought. Thank you again for wrestling with this, and I appreciate your
Mr.
time.
Lyon, any questions for Mr. Lyon? No, thank you for coming. Any other neutral testimony? No. Then Senator Hansen to close. Thank you.
Thank you, Senator Pansing Brooks and members of the Judiciary Committee. Again, let me thank you for hearing these 5 bills in succession. Part of the reason we decided to split them up in packages, I felt that kind of each one of these is a real discrete, concrete component. And I thought just maybe in a longer, comprehensive bill, a section like this would be glossed over as a repealer, and we'd get a lot of attention to other ones. And to me, this is very just kind of, as a lawyer, one that just jumped out at me when I heard it. Not only is it one of the highest standards, it's a separate standard compared to all of our Nebraska laws, and is a separate standard compared to all other United States landlord-tenant acts. It's a higher standard than commercial tenants, foreclosures, all criminal matters, divorces, child custodies. And our court system works fine. Our judges use their discretion fine in those instances. And despite all the opposition testimony we're here today, I don't think there was a clear public policy reason as to why this is a higher burden. Yes, it is. Landlords are on a tough spot. They are the plaintiffs in a case. But similarly, if there was a car crash, I'm sure a plaintiff's attorney would love to stop continuances in a car crash if they thought they had a slam dunk case. But we as a state don't allow that. Same with a prosecutor. I'm sure a prosecutor would love to stop continuances if he felt he had a slam dunk case. But we as a state don't allow that. And I don't know why we would have a separate issue for just purely for residents in a residential landlord-tenant act. And with that, I'll close.
Thank you, Senator Hansen. We do have 2 letters of support, 3 letters in opposition, and 0 letters that are neutral. And with that, we close hearing LB 396 and move on to LB 433 with Senator Hansen.
Thank you, Senator Pansy Brooks and members of the Judiciary Committee. My name is Matt Hansen, M-A-T-T-H-A-N-S-E-N, and I represent District 26 in Northeast Lincoln. LB 433 requires that a landlord return the balance of a tenant's security deposit with a written itemization of deductions within 14 days after the date of termination of tenancy. Currently, a tenant must first contact the former landlord and request the balance of the itemized list to be returned to them, and then the landlord has 14 days from that date to return it. It is important to remember that the security deposit is just that, a deposit of the tenant's own money for the landlord to hold in case damages is done to the property. If no damage is done that takes up the full amount, that money should automatically be returned to its owner, the tenant, regardless of whether or not the tenant contacts the landlord again after they move out. In other words, when the need for the, quote, security part of the deposit is gone, by default those funds should be returned to the rightful owner, the tenant. LB 433 also has a provision that says a tenant does not have to pay for damages that results from the removal from the unit by order of a governmental entity because it was not fit for habitation due to negligence or neglect by a landlord. If your apartment is condemned by the city, for example, and you are forced to flee with only a few hours' notice, you should not be charged for things like not cleaning out your fridge or have crayon marks on the wall. The urgency of being evacuated prevents a tenant from going through their usual steps of cleaning or making repairs. It makes sense that a landlord should be responsible for those types of damages if the reason the tenant had to rush to leave is a result of the neglect of the property of the landlord. The bill adds damages of 1 month's rent and court costs to what the landlord already owes to the tenant for violation of this section, which is the security deposit balance and reasonable attorney's fees. This part is important since currently, if a landlord fails to return a security deposit, the tenant is only entitled money owed and the attorney fees there is a judgment, which fails to have a detrimental effect. As with all my bills today, this bill will not make the process harder for landlords already using good practices. Those who already rightfully return tenants' deposits will not be affected. In fact, it will make it easier on landlords because they make the recording of new addresses and return of the deposit their normal move-out process and does not have to wait for tenants to return back to them. With that, I'd be closed and be happy to take any questions.
Any questions for Senator Hansen? No, thank you. Proponents, and just to remind everybody, please come down to the front row if you didn't know that. Also, if you hear testimony similar to yours, you can just sign the sheet at the back because your names will go in as opposition or proponent by that act as well. Thank you. Welcome.
Thank you. Good afternoon, members of the committee. My name is Alexa Barton, A-L-E-X-A-B-A-R-T-O-N. I'm a senior certified law student at University of Nebraska College of Law and was a co-leader of the Civil Clinical Program's Tenants' Rights Project. I'm testifying in support of LB 433 as a citizen and not on behalf of the university. I would like to discuss the legal reasons for changing 76-1416 to require landlords to return tenant security deposits. First, and most importantly, the security deposit is not the landlord's property. By requiring tenants to demand the return of their security deposit, the current law treats these funds as if they belong to the landlord. The security deposit does not belong to the landlord. It is not a fee or any other source of income for the landlord to use at its disposal. It is the property of the tenant held for purposes of security, and when the need for that security is gone, these funds should be returned to the lawful owner, the tenant. Second, Nebraska is an outlier in that it requires tenants to demand the return of their deposit. Only 5 other states besides Nebraska require tenants to make this affirmative demand. And the Uniform Act already contains a similar provision as what LB 433 proposes. Requiring landlords to return the deposit is commonplace, and LB 433 would simply put Nebraska in line with the vast majority of states and with the Uniform Act. Third, 14 days to return the deposit balance is reasonable. This is a fair compromise between the interests of the landlord and the tenant. Landlords will have 2 weeks to inspect the apartment and appraise its condition. Alternately, a tenant has an interest in the rightful return of his or her property within a reasonable time after the tenancy is terminated. These changes will not unduly burden landlords, as Senator Hansen said. This money does not belong to the landlords, so they are not losing any money. Landlords will still be able to make legal deductions.
The only change is that they must automatically return the remaining balance to the tenant rather than requiring the tenant to demand it. While the burden on landlords is minimal, the potential benefits for tenants are great. Tenants, especially low-income tenants, often rely on the return of their deposit in order to recover necessary expenses. Landlords are in a better position to be familiar with the legal system and legislative requirements related to the return of the security deposit. This is apparent from the number of landlords who are here today, whereas many tenants are unaware of this unique requirement imposed on them. In conclusion, LB 433 rightfully places the duty to return the deposit on those who are inherently more familiar with the system. At this time, I would invite any questions.
Any questions for Ms. Barton? Thank you for coming. Again, we're thrilled to have law students here. Welcome.
Hello again, Chairwoman Pansing Brooks and member of the committee. My name is Sam Raybine, S-A-M-R-A-Y-B-I-N-E. I'm a senior certified law student at the University of Nebraska College of Law, and I co-lead the Civil Clinical Law Program's Tenants' Rights Project. I am testifying in support of LB 433 as a citizen and not on behalf of the university. I would like to discuss the problems and consequences of requiring tenants to demand the return of their security deposit from their landlords. First, the demand requirement gives tenants the impression that their landlord has the right to refuse their request. The statutory language of 76-1416 appears to affirm, rather than correct, this misconception. Moreover, most tenants simply do not know that they have to affirmatively request their deposit to be returned. This provision disproportionately harms students and others who are less likely to be familiar with Nebraska's unique requirement. It is more reasonable to put the burden on the landlord, who is in the capacity of running a rental business, to know and understand that it is their duty to return the property of the tenant. Another consequence of the current language is that it incentivizes landlords to keep their tenants in the dark about their security deposit. Tenants who are unfamiliar with the law are vulnerable to exploitation by landlords who do not operate in good faith. This creates a windfall to the landlords who get to keep the deposit if the tenant does not ask for it back. This is especially egregious when you consider the fact that the money does not belong to the landlord. As Ms. Barton just explained, it is the tenant's money being held by the landlord as a deposit, not that dissimilar from a bank holding a deposit in a savings account. It does not become the bank's money, it is still your money. Third, and most important, the current law in particular disadvantages low-income tenants who are living paycheck to paycheck. This is a lot of money for low-income tenants, and they rely upon the lawful return of their security deposit. Section 76-1416 obstructs and delays its return. LB 433 would affirmatively put vitally important money back in the pockets of low-income tenants during the transition into a new home. A few $100s can make a big difference during this crucial period of time. Outside of facilitating their move to a new home, this money can pay for groceries, gas to get to work, school clothes for their children, medicine for sick family members, you name it. It's the tenant's money and they need it. Landlords will most certainly testify against this bill because they've been profiting off of this landlord favorable law for decades, and they want to keep profiting off of these poor tenants. They won't come out and say that, and they will likely come up here and provide other excuses for opposing this bill, but the true reason they don't like this bill is because the current bill has provided them a windfall for decades and they don't want to see that go away. All that this bill does is require that landlords give tenants their security deposits back within a reasonable amount of time, and that's all. Thank you very much.
Thank you, Mr. Raybine. Any questions? Oh, yes, Senator Brandt.
Thank you, Chairwoman Brooks, Pansing Brooks. Mr. Raybine, do you rent an apartment right now?
I do. I am a current renter.
Are you? So usually what is the going rate right now for a damage deposit?
Right now, going for myself personally, it was $350.
I mean, 1 month's rent, is that fair?
Yes, it is.
Usually what they put forward? Have you heard of landlords that have had damages far in excess of the damage deposits?
It's quite possible. Whether that exceeds $350, there are other legal remedies that they can pursue if they want to recover those costs and damages.
I mean, do you think the system is unfair right now?
In what regard?
In regard to what they're asking for damage deposits.
So I think what they're asking for a damage deposit is reasonable, but the mechanism for returning security deposits, which is not the landlord's money, is not reasonable.
I guess I'm confused. Can you enlighten me why that isn't reasonable?
Because we understand like the purpose of a security deposit, and as Ms. Barton explained, once the tenancy period is over, that money no longer belongs to the landlord. Now, if they need to make deductions for damages based off that security deposit, by all means, if it's a lawful legal reason for making those deductions, they're more than welcome to do so. But once those deductions have been made, it should be the landlord's affirmative duty to return the balance back to the tenants.
And in a lot of cases, that is not happening in the state of Nebraska?
They are under no obligation to do so.
But is that common practice that it is not returned?
No.
Okay, thank you.
Any other questions? No, thank you, Mr. Rabine.
Thank you.
Welcome.
Welcome. Thank you, Chairman Pansing Brooks. My name is Sarah Rips, S-A-R-A-R-I-P-S. I am an attorney with Legal Aid of Nebraska. As Mr. Mertz said earlier, Legal Aid of Nebraska is a nonprofit law firm that is dedicated to providing low-income Nebraskans with quality legal services that they otherwise would be unable to afford. One of the legal services that Legal Aid of Nebraska assists with regards housing issues. The significant number of our housing issues involve landlord-tenant disputes. These landlord-tenant disputes often occur because of the disparate levels of knowledge between landlords and their tenants. Tenants do not know the law as well as their landlords, and landlords take advantage of this. One of the reasons that landlords have this higher knowledge of law is because they often have attorneys on retainer who explain the laws to them and counsel and advise them on their rights. Security deposits are not the landlord's money, as both of the civil law school clinic students explained. The security deposit is not the landlord's money, and it should not be treated as an income profit center for landlords. As to my clients, the security deposits are a substantial amount of money to them, whether it is a $200 deposit or a $1,000 deposit. Many of my clients erroneously believe that their landlord had a good reason to not return the security deposit, or that they were not entitled to receive the security deposit back at all. In our Access to Justice clinic, almost every single day that we are open, educate our citizens in their rights and responsibilities. And that includes explaining to them that they have the burden of requesting their security deposit back. I help them draft letters to send to their landlords, and I help them when their landlords are purposefully obstinate in returning their deposits. Even though Legal Aid of Nebraska can make an impact on an individual level, it is a drop in the bucket compared to the immense change that the passage of LB 433 would bring to the quality life of our citizens. This is not an onerous burden for landlords because, as I mentioned earlier, this money is not their money and it should not be treated as such. The passage of LB 433 will elucidate to landlords and tenants that the security deposit is the property of the tenant. Thank you.
Thank you very much. Anybody have questions for Ms. Rips? I guess I have a question. So you heard the last comment that and I think one of the students said that there aren't many cases of this. Can you talk about the number of cases you all have?
So, unfortunately, I can't provide you with exact numbers, so this will have to be anecdotal, but I can supplement later. For the people we meet with, I would say that the vast majority of people do not understand that they have an affirmative duty to ask for their security deposit back. They just assume that they did something to not get it back.
Okay. And do you have, you don't know how many cases you have per year through legal aid?
In the information I handed you, it does lay out, I believe that we do about, of the 12,000 cases that we closed, that about 1/12 of those, about 1,000 cases involved landlord-tenant issues.
Okay, thank you very much.
Thank you so much, Chairman Pansing Brooks.
Next proponent. Welcome.
Hello again, Dr. Erin Feitstinger, Community Outreach and Advocacy for Together in Omaha. I'm here on behalf of our organization in support of LB 433, and I'll keep this very brief because everyone has affirmed what we also believe, especially as it pertains to the unequal knowledge for our clients who are low-income renters. I also just want to address what Senator Brandt asked and your question, Senator Pansing Brooks. I polled our case managers about this before we came in, and so 25 individuals, or 25 families and 41 individuals we helped house last year. Every single one of those clients did not receive their security deposit back from the last time they rented because they did not know that they should ask for it, which meant that when it came time for them to get housing this time around, they did not have any money, they did not have enough money for a security deposit and first month's rent. So we are supportive of LB 433. We think it levels the playing field and will have a tremendously positive impact on the lives of those we serve. So I'm available for any questions.
Any questions? Nope, thank you very much, Dr. Yes, welcome.
Good afternoon, Senator Pansy Brooks, members of the committee. My name is Kevin Ruser, K-E-V-I-N-R-U-S-E-R. I'm a professor of law and director of clinical programs at the University of Nebraska College of Law. Before joining the law faculty in 1985, I was a managing attorney at Western Nebraska Legal Services, which is now part of Legal Aid of Nebraska. During my 40-year career, I've worked on a number of residential landlord and tenant cases. I'm testifying today on my own behalf and not on behalf of the university. I'd like to focus on another provision of LB 433, which is the proposed amendment that would allow a tenant to seek liquidated damages equal to 1 month's rent if a landlord failed to return a security deposit as required by LB 433. This amendment, I think, is probably troubling to some, but it would hardly break new ground. There are many other provisions in the Act that currently authorize liquidated damages, both as to landlords and to tenants. Examples would include damages for abuse of access, which is 1 month's liquidated damages, damages related to intentional interruption of essential services or unlawful ouster, 3 months liquidated damages, 3 months rent liquidated damages, damages related to a bad faith failure to deliver possession of leased premises, 3 months liquidated damages, and damages related to a tenant's bad faith holdover after termination of a lease, 3 months liquidated damages. So the Act provides liquidated damages in many circumstances because the harm suffered by an aggrieved party is difficult to quantify, and providing liquidated damages would achieve two things. One, it conserves the resources of the parties and the courts by eliminating the need for extensive evidence relating to hard-to-quantify damages. And two, it furthers the goals of the Act by encouraging both landlords and tenants to comply with its requirements. So in summary, I urge the committee to support LB 433. I'd be happy to answer any questions.
Thank you, Mr. Russer. Do you have a question? Nope. Thank you very much for coming and for bringing the students.
Thank you.
Yes, next proponent. Welcome.
Thank you, Senator Pansing Brooks. My name is Karina McCormick, C-A-R-I-N-A, McCormick, M-C-C-O-R-M-I-C-K, and I'm representing myself for this particular testimony. I really want to convey how essential it is to renters' finances of whether or not they'll get their security deposit back and in what timeline. I think maybe people who are homeowners or in different financial situations don't understand how big of a difference that can make. And the dread and anxiety from the uncertainty of not knowing whether you'll get your deposit back is horrifying, frankly. I have a good landlord now. I trust that he will give me my deposit back. But in a previous, with a previous landlord, I had no idea. And he had been so unresponsive to me for the entire time we lived together that I was guessing I wouldn't get it back, and I didn't know what I could do, and it was completely up to him how long he wanted to give it back to me in. And at the time when I was moving, the degree of anxiety that caused to me stopped me from being able to make good plans, all those sort of things. And this simple bill would take away that kind of stress for so many renters. I eventually did get the deposit back months later. He also found an entire another month's rent bill check that he just lost. That's the sort of thing we're dealing with these landlords. And renters really need the certainty of knowing the timeline with which they will get their deposit back, and they shouldn't have to ask for it because it's their money. It doesn't make sense. It's not logical to think that they should have to ask for it back, and it will provide a lot more continuity and certainty to renters' financial situations with this easy bill. So I ask you to support it. Thank you.
Thank you for coming. We appreciate your voice representing yourself.
Thank you.
All right, next proponent. Welcome.
Hello, Senator Panting Brooks, committee. My name is Renee Just, R-E-N-E-E-J-U-S-T. I am testifying on behalf of myself. I have been a tenant for about 10, 15 years. I've lived in at least 8 different places, and I recently graduated law school, and I had no idea that I had to demand my deposit back. And I'm somebody who is relatively sophisticated, and I wasn't aware that that was my affirmative duty. In the places I've lived, I have gotten my deposit back most of the time. I almost have never gotten a full deposit back, but every time I've gotten a deposit back, except a couple times, I've been told what it's been used for, whether they've replaced light bulbs or something that comes up, whether it's stove covers. I've always had an idea of why I did not get money returned to me, and I've never questioned it. It's always been very reasonable on what a landlord needed to do in order to get my unit back into a shape where they could charge reasonable money for it. There have been times that I did not get a deposit back, and I just assumed that they spent it all on I don't even know what, but it is very stressful to not get a deposit back and to not even realize that you had this duty to do something in getting your own money returned. I welcome any questions.
But thank you for coming and telling your stories, personal stories. Thank you. Next proponent. Okay, opponents. Welcome.
My name is John Chatelain, again, John-Chatelain. I'm speaking on behalf of the Metro Omaha Property Owners Association and also the statewide Property Owners Association. And we oppose LB 433 because it proposes to change a statute which is a good statute. It proposes to change it to start the 14-day clock ticking on the termination of the tenancy rather than the demand and designation of the location where the payment or the accounting may be mailed. The question then becomes really a matter of mechanics. We oppose this bill because of the mechanics, because it's not clear when exactly the tenancy would terminate. Suppose there are multiple college students living in the house, and you know how that often is. One moves out, another one comes in to fill that slot, and there's kind of a continual rotation of students. When does the termination of the tenancy for the one that moved out? And would the landlord even know that the tenant considered their tenancy terminated? It's not a large imposition upon the tenant to write a letter or to make a demand to the landlord, say, hey, I need my deposit, or I need an accounting of my deposit. The problem with this proposal is we don't know when the termination is going to occur. Another situation is what we've talked about earlier. When a tenant is being evicted, does the tenancy end at the expiration of the 3 days from the 3-day notice, or 30 days from the 1430-day notice, or does it end when the judge enters the judgment restoring possession of the property to the landlord? Is that when it ends? Could the 14-day clock start running when at the expiration of the 3 days, or at the judgment, or when the tenant is locked out after the judicial proceedings? So it's very unclear just when that occurs. Some of the testimony of proponents were to the effect that the deposit is supposed to be returned. That is not the case. Either the deposit or a written accounting for the deposit. Oftentimes the deposit is used up because of rent that is owed or damages to the property. Under this proposal, the 14-day clock could expire before the landlord even gets the property back to be able to survey possible damage to the property, to be able to make the accounting. The other troubling thing about this bill is the expansion of the penalties. Currently, the statute provides for damages to the tenant plus attorney fees if the tenant is successful in the lawsuit over the deposit. But this bill would then add liquidated damages in addition to the actual damages of 1 month's rent plus attorney fees. The landlord would then be in a very difficult position of not knowing when the tenancy terminated, but then having to pay the landlord's attorney fees and also the tenant's attorney fees. So it would almost be forced to settle with that tenant and give them money that they were not entitled to. So it's basically issues like this that we would have to oppose this bill. I think without adding the additional liquidated damages and then leaving that demand requirement along with the address of where to send the deposit or the accounting, then we would have no problem with it. But it's the problem of knowing when the termination occurred. Are there any questions?
Yes, Senator Moorfield.
Okay, so there's a lot to unpack there. So you're basically opposed to the entire bill. Which part of the bill are you in support of?
I would support the bill as it is, the statute as it is.
Well, no, I'm talking about the bill. The statute is statute. This is a bill. So which part of the bill would you support? Because it sounded like you said you wouldn't.
I don't think the bill is necessary at all because the statute is a good statute.
Do you think that it's the responsibility of the tenant to request their security deposit?
You know, some of the testimony was to the effect that the tenant would never get the deposit back unless they requested it. I don't think that's the case. The landlord oftentimes does send the deposit or the accounting without the request.
Okay, but the problem is that that's not always the case, and I know that personally not the case. So I appreciate everybody in here is perfect landlords and doing really well, and I know a few of you personally. I know that's probably the truth, actually. But what about the bad landlord that doesn't send it? Do you think that they should be required to send it without the request of the tenant?
I think they should, if they know where to send it and there is some money to be returned, I think they should send it even without the written demand. But it's a matter of mechanics. If you're going to be imposing damages upon the landlord, particularly liquidated damages of 1 month's rent plus attorney fees, we better know when that 14-day clock starts running. We need to know that.
Okay, fair enough. But going back, do you think that it should be the responsibility of the landlord to send a security deposit to the tenant? Do you think that the tenant should be required to have to request a security deposit at the end of the term of the lease?
I think that the landlord should return the security deposit if there's any due and owing, with or without a demand.
Okay.
However, if you're going to impose these damages upon the landlord, then I think we need to know when that clock starts running, and therefore you need the written demand, or you need the demand from the tenant to the landlord if you're going to impose these damages on the landlord.
Okay, thank you.
Okay?
Anything else? Yes, Senator DeBoer.
Thank you. I think some of what you were saying to Senator Moorfeld helped me out a little bit, but also I wanted to just sort of ask you, it seems like your concerns here could fairly easily be addressed. We could address the issue of, in the case of a termination, when is, or an eviction, when is the termination for purposes of this section. We could also address the question of what to do, about multiple individuals living. Would you be willing to work with the introducer to clarify the language so that we can, in fact, codify the idea that you said you like, where the landlord should be sending money back to the tenant if there is money remaining after you've taken out for whatever you need?
Well, I agree that that is the right thing for the landlord to do if there is money due and owing to the tenant.
Yes, if there's money.
But this statute is talking about assessing damages, including liquidated damages of 1 month's rent plus attorney fees. And so if that's where this is going, then the landlord needs to know when that 14-day clock starts running.
I agree with you. You ought to know when your clock starts running, but I think that that's something that we can write in a statute, is when the clock starts running.
Well, it's already in the statute. It's when demand occurs, when the tenant makes demand and tells the landlord where to send it, that's when the clock starts running.
We can write a bill, sir, I think, that would say when the clock would start running, which would address your issue, which is you don't, under this bill, understand when the clock would start running. So if we can write a bill, sir, that says when the clock starts running, would you be okay with then making this change to the law, which would then shift the burden from the individual tenant who does not participate more than just on the occasion of their own tenancy in these kinds of transactions to the landlord who does, to determine, okay, now we must pay whatever is left after the correct things have been taken out?
Well, we do have a statute now that is very clear about when the clock starts running, and that's when the demand is made by the tenant.
Right.
And I don't think that's a large imposition upon the tenant to contact the landlord and say, hey, what about my deposit? Can you send it to me? And it should be in writing as well. I don't see why tenants aren't helpless here. I don't think they're babies. I think we need to put some responsibility on them to have that duty if they want to start this clock running where they're going to sue the landlord and get a judgment against the landlord, including attorney fees. I don't see that that's a large imposition on the tenant.
I understand that you don't see that that's a large imposition, although we did hear testimony saying that there are many people who fairly savvy about the law, graduate from law school. I myself did not get my money back because I didn't ask for it, because I didn't realize that was the law. I'm an attorney, now I'm a senator, and I didn't realize that. Now, this was before I was a senator, but still, there are people out there who don't realize this. That's fine, but it seems to me that the person who deals in the normal course of business with this sort of thing might have the better position for determining who would be, that the deposit ought to be returned. There's not a question in there for you, sir, but I would ask that Senator Hansen work on that language to make sure that if this bill goes forward, we can take care of your concerns about making sure that those dates are very particular and that there are some in place for you all.
I'm always open to considering things and talking to anyone about these issues, so by all means, he could contact me.
Great, thank you.
I think that's what you were asking.
I wasn't asking, but yes, that's what I was saying.
Thank you very much.
So I'm not done to either. So,
Okay.
Mr. Chatelain, have you worked with Senator Hansen on any of this?
No, unfortunately, these bills were all introduced, and to my knowledge, no landlord association or landlords were contacted before these were introduced, which I think is somewhat unfortunate.
Well, with the speed of how things work in the legislature, it's pretty hard for us to contact every group that might be interested, that's for sure. But you talked about the fact that that the bill, that you wouldn't know where to send it. And I think that the bill provides that the last known address is where you would send the money. What about, why don't the landlords put in their rental agreement the notice of the fact that if you believe the landlord should be doing this, then you should be giving the tenant, if you believe the tenant should be notifying you that they want their money back, which I think you would know when they're leaving anyway, and you're going to have to re-rent it. But why don't you at least put in rental agreements that the tenant has to do this? I mean, if so many people have come forward and said, we had no idea that we had to contact the landlord. And of course, I have anecdotal evidence that where landlords, where I've been told, just don't, forget it, kiss the deposit goodbye. So I know you don't think that happens because you're good at what you do and that you represent all good people, but there are landlords that just do come and say, this is something that, there's a stain here, or so there are people that act in bad faith, obviously, on all sides, the tenants, the landlords. Isn't it better if we have knowledge and communication and transparency on what is going on?
Well, Section 761416 already provides for that situation where the landlord is being irresponsible about communicating with the tenant regarding the deposit.
Then the tenant has to come and file the suit and claim all of that.
Yes, and then they get attorney fees. And
so generally, the theory today is put all onus on the tenants. Don't help them. The tenants are people that are in a different position. They're generally students or people that don't have the knowledge of the business people that we have here today, who are business people with great knowledge of landlord-tenant law, of how to protect yourselves, how to protect your property. And so landlords are dealing at a higher level and a more knowledgeable level than a tenant, right? Wouldn't you agree with that?
I don't know that I would make that assumption. We have some tenants that are very savvy, and they are professional litigators, and I see them in court all the time.
How many is all the time? How many per year do you see?
I probably have half a dozen cases right now that I'm defending landlords from aggressive professional litigators.
Statewide?
Tenants. In Omaha.
In Omaha. Okay, thank you very much.
Okay, thank you.
Next opponent. Welcome.
Thank you. Senator Pansing Brook and members of the Judiciary Committee, my name is Carrie Davidson, that's spelled Kerry Davidson. I'm the Executive Director of both Good Samaritan Society Superior and Good Samaritan Society Hastings Village, and I'm a proud member of the Nebraska Healthcare Association. I'm here today to testify in opposition to LB 433. The Good Samaritan Society is a nonprofit organization that was founded in 1922 and is driven by a mission to share God's love with seniors and others in need. Our Hastings campus, along with several other senior living complexes across the state, provides independent living apartments for seniors in addition to skilled nursing facility care and assisted living services. Independent living is an option for individuals who need only minimal assistance, like meals or quickest response help in an emergency situation. These independent apartments for seniors fall under the requirements of the Landlord and Tenant Act. Our concern is only with lines 15 through 19 of the bill, which requires the deposit be returned to the tenant within 14 days of termination of occupancy. It is our goal to return as much of the tenant's deposit as possible. However, the inflexibility of this requirement means we may not have sufficient time to gather quotes from contractors in scheduled repairs. Currently, it is our practice to try less costly options first, like having the stain in a carpet cleaned rather than just replace the carpet. But this can take additional time. However, this approach allows our organization to return as much of the deposit as possible to the tenant. The seniors moving from these independent apartments are often moving to a higher level of care and may need assistance from family in downsizing their belongings. If family members are out of town, a more flexible time frame allows us to help the senior move to a higher level of care while leaving his or her items in the apartment until the family can make arrangements for them. I understand the goals of LB 433 is to protect the tenant. I just wanted to make the committee aware that when it comes to seniors living in independent apartments, an unintended consequence may be that there may not be time to explore lower cost approaches to repairs, and other arrangements may need to be made when the senior is moving to a higher level of care. Thank you for your time, and I'm happy to answer any questions.
Thank you, Ms. Davidson. Yes, Senator DeBoer.
Hi, thank you, Ms. Davidson, for testifying today. Would something like 30 days be more helpful? Is this a...
That would be exactly what we really do. We are the type that have it in our occupancy agreements that are done on a 30-day basis. All of those pieces are in there, but giving them the option to not request it for, let's say, 17 days, gives them 17 days that they've got all that time to move out, because we can't go into a unit and look at any kind of repairs until after they've moved out. For an example, somebody rips the linoleum on the carpet, moving the refrigerator out. We will try to patch that and not have to replace the entire kitchen's worth of linoleum. So we need time to be able to come in and find out if that's an option or not. Because if we can patch it, we're talking $100 versus $1,100 replacement. So that's just ultimately our goal. And like I said, it's just part of the consequences for our seniors, however.
So would your opposition go away if that changed to 30 days?
It definitely would, because we do give it back.
Thank you.
And prorate the monthly rent.
Okay, thank you very much for coming. Next opponent.
Thank you.
Good afternoon. I'm Dana Steffen, D-A-N-A-S-T-E-F-F-A-N, and I'm a fee-based property management company here in town, and I do return those security deposits within the 14 days. And a lot of the points I was going to make have already been brought up, but I just don't understand it being a burden. Now, when tenants do give me notice to vacate, I send out the move-out packet. In that packet does contain the demand letter. They just need to fill in the blanks. Another sheet in there gives a checklist of things they need to complete. Make sure, look under the refrigerator, clean under there. Check the mini blinds, just the typical stuff a lot of tenants tend to miss, like the burner pans. Those were mentioned earlier. We give the tenants notice to that. 100% of my tenants get that letter. I only get maybe 30% of those letters back. So the tenants are notified. They still don't return it. They still don't give me the demand letter. I also get demand letters written on napkins. I take it any way I can get it, just anything. And then the concern of multiple people living in the home. Who gets the money? I have it that I've returned it to the first person on the list. That's the first one entered on the lease agreement. That's the one I return it to. Second one calls and complains, well, I was supposed to get it. And my favorite, you need to split that up. They did that damage, this person did that damage. I feel I should get 80% of the deposit back and the other 20% should be split between the other two people. By providing that demand letter, that takes it out of my hands and tells me, gives me direction exactly what needs to be done, who gets the money back, where it needs to be sent. Just last week, I had a tenant call me. He had moved out in July, and he said, you did not return my deposit, and I want it back. I said, great, let me check on that. I checked on that. I found the check, provided a copy to him. It says, well, we did return it. Here's the copy of the check that went through the bank. And he thought his roommate took it. Well, it was made out to him. Sometimes they forget. Again, is it a real burden to return that letter? I send those letters out all the time for demand back. And also, I wanted to mention, it's education. With social media, by God, everybody wants an emotional support animal. I know we're not here to discuss that, but with social media, why not get it out there? Hey, tenants, you need to demand your deposit back. Go for it. I think, clarify me if I'm wrong, I think they have up to 2 years to do that. So, you know, if you moved out and it's a year down the road, go for it. Make that request. Again, I return them within 14 days whenever possible and send them to the last known address. Thank you. Any questions?
Thank you.
Thank you.
Today. Mr. Storr, welcome.
Again, Larry Storr, 5015 Lafayette, Omaha, Nebraska. This might be a little bit of a stretch, but I've been following things at the county and the city and here for a couple of years now. And I want to suggest something that under the state constitution, once again, Article 3, Section 15, nope, I'm sorry. Article 3, Section 16 has to do with contracts. Municipalities and states and entering into contracts which may be contrary to the law. Conflict of interest, I believe the term is. It just seems very strange to me that with the recent developments regarding the K apartments in Omaha, that this morning we have in the World Herald announcement that there's a counter lawsuit by the owners of K apartments. And as I'm reading this bill, it seems very similar to what's been going on there. However, a tenant shall not be liable for damages directly related to the tenant's removal from the premises by order of any government entity as a result of the premises not being fit for habitation due to the negligence or neglect of the landlord. Okay, we don't know that until after the fact, do we? And it has to be adjudicated. But as I understand, a law is a contract. Our Constitution was based on English law, and most of that was all derived out of certain contracts that may have started with social contracts, but I think I learned in business law class many years ago that law is sort of a contract between the government and the people. So, you know, I do pay rent to the county, and I do pay rent to the state through state income tax. You probably get part of my property tax also. But I do know that Justin Wayne and the mayor of Omaha have been talking about this, and it makes me wonder if their Attorney General maybe should look into the possibility of a conflict of interest. Thank you.
Thank you, Mr. Storr. Any questions? Oh, thank you for coming. Anybody in the neutral? Oh, more. I'm sorry. More opponents. If you guys could come down for us, that would be helpful. That's okay. We just thought.
I thought I could just slip in.
Thank you. Mr. Fisher, welcome.
Thank you. Lynn Fisher, L-Y-N-N-F-I-S-H-E-R. Try to be even briefer if I can, since we've most of the points have been covered. In other states, the deposit amount can be more than 1 month's rent. And one of the reasons why we have a lower amount in Nebraska, my understanding is to give some advantage to the tenants to limit the amount of deposit that they're required to provide. We love giving deposits back. If tenants would automatically pay for damages as they leave, we wouldn't even need a deposit, but we have to have that because in most cases they would refuse to do that. I would characterize the money as not being the tenant's money until it can be determined that there are no damages or that part of the deposit should be theirs for damages less than the amount of the deposit. So it isn't their money until we determine what the damages are. And we love giving back the whole deposit. That means we save a lot of time and expense. On a personal note, I'd be happy to work with Senator Hansen on coming up with a way to educate tenants. I personally always send the deposits back within 14 days, and we always tell our tenants what their rights are, and I'd be happy to work on some kind of a compromise to educate tenants about their rights.
Thank you.
Any
Mr.
questions?
Fisher. Any questions? Nope. Don't see more opponents. Okay. Any other opponents? Okay, neutral testimony, if you please.
Do you have my name, or do you want me to spell it? Scott Hoffman?
You just do it, yeah.
SCOTTHOFFMAN. Well, this has always been kind of a touchy subject. We've always given our tenants deposit back, especially after they move out. When it involves an eviction, it's usually going to go south. But according to my attorney, he advises me to make up a list of everything and to mail it to the last address. Obviously, the deposit's probably going to be ate up, and then give a definition of all the damages. Now, mostly, let me pull this out. I don't know when this law was created, 40 years ago, but we live in a cell phone area, a simple text or a phone call. I mean, that could be a demand right there. I mean, seriously, where's my deposit at? Yeah, you're going to get it back within 14 days. A lot of times we rush it. Sometimes it's within a few days after they move out. Most of the reason why, because I own houses, we'll hold the deposit until we get the water bill, because the water bill is assessed to the property. My one concern is, and I'm not done yet, but with Senator DeBoer not getting her deposit back because she didn't know, I don't know if she ever tried to call the landlord or anything to make sure, but seems like a simple contact. A phone call. This is where I live. Where do we send the deposit to? That's pretty much why I've stayed neutral on this, because this is a touchy subject. So, but other than that, that's about it. So, yeah.
Thank you.
All right.
Questions? No. Thank you very much for coming.
All right, thank you.
Any other neutral testimony? Oh, Senator Hansen for closing.
Thank you, Vice Chair Pansing Brooks, members of the committee. Just being real brief, I'm not 100% sure how to address some of the opposition today for this particular bill, because some of the opposition seemed to be opposition to the current statute. 14 days is current statute. Termination of the tenancy is current statute. Of course, I'd be happy on that. When exactly does the tenancy end? Be happy to provide some clarifying language. And I will say, I do want to say, comparing this bill to the last bill, on the last bill with continuances, especially talking about the evictions related to non-payment of rent, 14 days was portrayed as this huge amount of time to come up with your rent money, and now in this bill, 14 days is so quick of a time to return a security deposit. So I'll just leave that as food for thought for the committee on as we weigh all these different dates and different statutes and different burdens. And I will close my testimony.
Thank you, Senator Hansen. We do have 2 letters of support for the record, 2 letters of opposition, and 0 neutral letters. So thank you. And with that, we close the hearing on LB 433. And next we have LB 434 from Senator Hansen.
Thank you, Vice Chair Pansing Brooks and members of the Judiciary Committee. My name is Matt Hansen, M-A-T-T-H-A-N-S-E-N, and I represent District 26 in Northeast Lincoln. Nationwide, when a tenant is late on rent, by law, a landlord must provide written notice to the tenant that if they fail to pay in a certain number of days, then landlord will terminate the lease and initiate eviction proceedings. States differ, however, on exactly how many days' notice a landlord has to give. In Nebraska, we require just 3 days' notice. LB 434 aims to lengthen the notice requirements that landlords must give tenants